Good morning and welcome to day two of the Public Service Commission's hearing in docket number 2019-182E. We'll start this morning by taking roll call of commissioners. District 1,
Commissioner Williams is present in the hearing room.
District 3,
Present in the hearing room.
District 4,
Present virtually due to COVID-19.
District 5,
Present in the hearing room.
District 7.
Present in the hearing room.
I'm from District 2 and I'm present, and our District 6 commissioner is absent today due to military leave. Can we go ahead and take appearances from the parties? Dominion Energy.
Madam Chairman, this is Matt Gibson-Danner with Dominion Energy.
Thank you. Duke Energy Carolinas and Duke Energy Progress.
Heather Shirley Smith is on for Duke.
And your co-counsels?
Yeah, Ashley Cooper, Madam Chair. Ashley Cooper is on as well.
Thank you. South Carolina Appleseed Legal Justice Center.
Good morning, Madam Vice Chairman. Adam Prothero for South Carolina Appleseed.
Thank you. Nucor Steel, South Carolina.
Good morning, Madam Chair, Rob and Commissioners. Rob Smith, Moore Van Allen, representing Nucor Steel.
Thank you. North Carolina Sustainable Energy Association.
Good morning. This is Peter Ledford on behalf of NCSEA. With me is Jeff Kirkendall.
Thank you.
That's correct.
Solar Energy Industries Association.
Jeff Kirkendall.
Thank you.
Kirkendall here, Your Honor.
Thank you. Upstate's Forever, Coastal Conservation League, Solar Alliance for Clean Energy.
Good morning, Madam Chair. This is Kate Lee representing the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Upstate Forever.
Thank you. Alder Energy Systems.
Good morning, Madam Vice Chairman. This is Taylor Spear for Alder Energy, and our principal and witness, Don Zimmerman, is on the line as well. Thank you. Good morning.
Thank you. Office of Regulatory Staff.
Good morning, Madam Vice Chair. Jenny Pittman and Jeff Nelson for ORS.
Thank you. And Mr. Culley, I apologize that I skipped Volt Solar, but Volt Solar. I see you up there.
No problem at all. Good morning, Madam Vice Chair. Thad Culley for Volt Solar, joined by Beth Grant, Sal, and Durant.
Thank you, and I do apologize for skipping over you. Today is Wednesday. We have our regularly scheduled business meeting today. So the schedule that I hope that we can stick to today is that we will go to approximately 1 o'clock today. We will take a mid-morning break, and then we will reconvene hopefully by 2:45. So to give you a little bit of idea of how we plan to go today. And then we will go to 5-ish, 5:30, somewhere in there. With that in mind, I know that we have some witnesses that need to get up today. Duke, we're in the midst of your case, and you had 2 witnesses that couldn't be here yesterday. Are all of your witnesses available today?
Yes.
Okay. And then I believe we had another party that needed to get a witness up today. Is that correct?
Correct. Madam Vice Chair, Council had discussed this matter prior to today's start of hearing, and if it pleases the Commission, Duke was prepared to go ahead and put up Lee Ford and Chip Wright, and then we had 2 out-of-order witnesses that needed to go up today, and councils for the other party speak to that, but we were amenable and flexible to working with those schedules. We had just preferred that our case be interrupted only once.
Okay, thank you very much. And whose witnesses need to go up out of order, please?
Madam Vice Chair, Thad Kelly for Vote Solar. We'll be presenting a joint witness on behalf of many of the parties here, and I won't recite them all now for sake of time. Witness Tom Beach, and we would propose that he immediately follow DEP witness Wright, and we appreciate the company's flexibility and accommodation.
Okay, thank you all, and please know that the commission also appreciates the parties being flexible and working this out. We certainly appreciate y'all working that out. Okay, please.
Vice Chair Peter Ledford with the North Carolina Sustainable Energy Association.
Yes, sir.
Witness Justin Barnes, who is appearing on behalf of NTSEA and SIA, also has a time scheduled to testify in Kentucky tomorrow. So we would propose to put him on after Witness Beach.
Okay. So our order to begin with will be Ms. Ford, Dr. Wright, then Mr. Beach, and Mr. Barnes. And then we'll go back to the regular schedule. Is that correct?
Correct.
Okay. Thank you very much, parties and attorneys and witnesses, for working those out for us. Any other preliminary matters before we get started? Hearing none, Ms. Smith, I believe we're in your case. Please proceed.
Thank you. Madam Vice Chair and members of the Commission, at this time we'd like to call Ms. Lee Ford stand.
Ms. Ford, are you on the stand? There you are. Please state your name and who you're with, please.
Good morning. My name is Lee Ford, and I'm with Duke Energy as a consultant.
Okay, and you will now be sworn in by the court reporter.
Ms. Ford, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole, and nothing but the truth?
I do.
Thank you.
Please go ahead, Ms. Smith.
Thank you. Good morning, Ms. Ford. Would you again state your name for the record?
Good morning. My name is Lee Ford.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy as a consultant.
Okay. And did you prepare or cause to be prepared 8 pages of direct testimony that were pre-filed by the Commission on October 8th in this proceeding?
I did.
And if I asked you those same questions that were asked in your pre-filed direct testimony, would your answers be the same?
They would.
Okay. Madam Vice Chairman, I would ask that Ms. Ford's pre-filed direct testimony be entered into the record as if given orally from the stand.
Ms. Ford's pre-filed direct testimony will be entered into the record.
Ms. Ford, did you also prepare or cause to be prepared 2 exhibits that were attached to your pre-filed direct testimony?
Yes, I did.
Do you have any changes to those exhibits at this time?
No, I do not.
Madam Vice Chairman, I would ask that Ms. Ford's pre-filed exhibits be entered as the next composite hearing exhibit.
Ms. Ford's pre-filed exhibits 1 and 2 will be marked for identification as hearing exhibit number 6 and entered into the record of the case. Thank you.
Ms. Ford has prepared a summary of her testimony, and we're going to walk through it just to be more efficient in a brief Q&A format. Ms. Ford, can you please explain to the Commission the purpose of your testimony?
Yes. Good morning. The purpose of my testimony is to provide a summary of the company's stakeholder engagement process, to summarize the input that Duke received, and to describe how the processes impacted the company's analyses with regard to net energy metering.
Did the companies and other interested parties proactively initiate stakeholder engagement processes?
Yes. After consultation with interested parties, the companies organized 2 stakeholder workshops regarding net metering. The first workshop was held on March 12, 2020, and had 42 participants. And at this workshop, the companies gave presentations regarding an overview of Act 62 as it relates to net metering, long-run marginal cost, cost of service implications of customer generators, and the company's future strategies regarding transmission and distribution planning. A presentation was also given by Vote Solar regarding cost of service implications of customer generators. The second workshop was held on April 23rd, 2020, and had 47 participants. The companies gave presentations regarding the value of distributed energy resources under the Act 236 methodology, options for successor tariffs and rate design based on examples from other states, and options for an Act 62 compliant tariff. A presentation was also given by Sunrun regarding potential considerations in evaluating the direct and indirect economic impacts of net metering in South Carolina.
Did these presentations generate feedback?
Yes, they did. At the workshop, stakeholders provided feedback. Some feedback included a view that economic experts should be utilized in determining the cost and benefits of net metering, and that the economic value of net metering should include jobs created, income invested in the local economy, and tax generated by solar businesses. Stakeholders also provided feedback that in thinking of the local economy, the term local should be defined as within the borders of South Carolina. Stakeholders also gave feedback that locational specific incentives for customers connecting to the grid should be considered. The companies agreed with stakeholders that the definition of local economic impact should remain within the state borders, and that economic experts should be utilized to address the indirect and direct economic impacts of distributed energy resources. We also discussed many of the foundational concepts of net metering.
Did the companies find these stakeholder engagement sessions informative?
Yes. The companies were very pleased with the stakeholder engagement process and believe that the parties walked away with a better understanding of the concepts and matters to be addressed in this docket. The feedback shaped the company's filing in this docket, and the companies appreciate the time allowed by this commission to work with the stakeholders. The companies look forward to continuing to collaborate on net metering matters in the future. This concludes a summary of my testimony.
Thank you. Madam Vice Chairman, the witness is available for questions.
Thank you, Ms. Smith. Examination, Dominion Energy.
No questions for this witness.
South Carolina Appleseed Legal Justice Center.
Briefly, Madam Vice Chairman, I do have a couple of questions. Good morning, Ms. Ford. How are you?
Good morning. Doing well.
Thanks. I'm glad you can hear me as well, too. We'll get through this technology thing together. Just a quick question. Are you familiar with the proposed settlement that's been filed in the solar choice tariff docket by the Duke companies?
I am.
Okay. And in that proposed settlement, are you familiar with language that briefly discusses the possibility of exploring low-income programs for solar choice?
Yes.
Okay. And that language is essentially a commitment to explore those programs, but not any kind of a commitment to adopt any particular program. Is that right?
I believe that's the case. I'm not directly familiar with that piece, but I believe it is to explore options.
Okay. Are you aware of any other commitments by the companies or industry as part of this proceeding or the solar choice tariff proceedings to engage or either create or expand any types of low-income programs?
I don't have that information offhand. I do recollect it being in that agreement, but anything further I don't have with me.
And that agreement was the language to explore that possibility, correct?
Correct. Yes, that's correct.
Okay. Okay, thank you. I don't have any more questions.
Thank you, Mr. Prothero. Nucor Steel, South Carolina.
No questions, Madam Chair.
Vote Solar.
No questions, Madam Chair. Thank you.
North Carolina Sustainable Energy Association.
Madam Chair, this is Peter Ledford. I've got just a couple of questions.
Please proceed.
Thank you. Ms. Ford, you discussed extensively in your testimony the stakeholder meetings that Duke held earlier this year, this spring. How did Duke invite stakeholders to the meetings or otherwise let stakeholders know they were happening?
Sure. Good morning. As evidence in this docket, Vote Solar initially sent a letter to the Commission stating that they suggested stakeholder meetings to start to address some of the components of Act 62, and Duke concurred with that. As I'm sure you're aware, Duke does extensive stakeholder engagement, and so in the beginning of this process, they identified parties who had been a part of prior Duke stakeholder engagement opportunities, and identified those parties and reached out to them. Concurrently, Vote Solar and other interested parties were reaching out to counterparts to invite them to the stakeholder meetings as well. Duke also filed in this docket public notices of initially that we were beginning the stakeholder engagement process in collaboration with Vote Solar and other parties, and then filed also in the docket the date of the stakeholder meetings that would be taking place, and those were filed in advance of the docket to notify anybody in the public or anyone who was following along with the docket that these opportunities were available. And then once the stakeholder meetings began, during the meeting, as in my Exhibit 1 in the meeting minutes, we asked if there were other interested parties who perhaps didn't get invited or weren't aware of it, for those that were participating to notify me directly. And there were a couple parties that notified me, and those additions were added to future stakeholder meetings.
Thank you. And to your knowledge, have any other utilities held similar stakeholder meetings in South Carolina?
I'm familiar with what Duke has done, so I'm not sure about the others.
All right. Thank you very much. That's all I had, Madam Chair.
Thank you. Solar Energy Industries Association.
No cross from SIA.
Upstate Forever, South Carolina Coastal Conservation League, Solar Alliance for Clean Energy.
Good morning, this is Kate Lee. We have no questions for this witness.
Thank you. Alder Energy Systems.
Good morning, Madam Vice Chair. Some questions, please.
Please proceed.
Thank you. Good evening, Ms. Ford. My name is Taylor Spear. I represent Alder Energy Systems, LLC. How are you this morning?
I'm doing well. I hope you are.
I'm well, thank you. I appreciate you asking. Do you know who my client is?
Yes, through this proceeding, I've learned more.
Well, did you know about them before this proceeding?
I was familiar with Alder Energy and work that they did in other parts of the state, yes.
And you've had conversations with Alder Energy's principal, Don Zimmerman, many times in your capacity when you worked for ORS, is that correct?
We did work together through Act 236 activities.
Right. So Alder Energy was involved in stakeholder processes for Act 236, either in its own name or in Don Zimmerman's name, correct?
We're going way back in the memory bank, but I believe that is correct. I wouldn't say definitively, but yes, I believe that's correct.
And you testified this morning that part of the decision-making process to determine who was invited in that proceeding was who had participated in prior stakeholder meetings with Duke Energy, correct?
In Duke-specific stakeholder meetings, that is correct.
Well, why wasn't Alder Energy Systems, LLC, my client, invited to participate in those meetings?
We identified participants in Duke-specific stakeholder meetings, and Alder has not been a part of Duke-specific stakeholder meetings. And, we did make public filings that listed the dates that we were having the stakeholder meetings, also that stakeholder meetings would be taking place. And had we known Alder was interested, they would have been more than welcome to join. But with the public filings as well as industry participants, we felt that we made a good faith effort. I would also note that the SBA, which Alder is a part of, was invited to the stakeholder meetings, and then SIA, which Alder is a part of, participated in the stakeholder meetings. So I would say that their interests were represented.
SBA is not an intervener in this docket, are they?
They are not, but they were invited to the stakeholder meetings.
SIA is an extremely large national organization, isn't it?
I don't know their size.
Well, would you agree with me that they could be involved in any matter of stakeholder meetings or policy processes across the country in which an individual member would not know that that was happening?
know the inner workings of how they communicate with their members.
Would you agree with me that Alder Energy Systems LLC, my client, Don Zimmerman, who is on the line right now, participated in other Duke Energy shareholder meetings, including community solar stakeholder meetings?
I don't know that.
If that were to be the case, and testimony was elicited from my client at a later time that Alder Energy, in its own name or in Don Zimmerman's name, had participated in those stakeholder meetings, would you have an explanation as to why then, based on your own testimony that the criteria was prior participation, why Alder Energy was not invited?
No, we looked through stakeholder activities, including ISOP, grid improvement, DSMEE, and Alder's name was not on that. Again, I'll go back to the public filings that were made, and other parties that are not interveners in this docket saw the filings and reached out to Duke to ask to participate, and we did include them.
Did you look at a list of participants and stakeholder meetings for community solar when you determined what your list of invitees would be for this proceeding?
I did not personally look at those lists. We have an entire stakeholder engagement group, and they help generate those lists. Do you know who at Duke would have looked at those lists or generated that information? I do not. It's a group we have, so I don't know an individual. You're a consultant, correct? You don't work. You're not employed by Duke. That's correct. Who is your direct point of contact in your activities with Duke as a consultant? I report through legal through Heather Shirley Smith. You matched, well, was non-residential net energy metering discussed at any of those meetings? I believe they were, yes. What's the basis for your belief? We looked at cost implications and net metering customers, and so there would be non-residential included. I, of course, did not do that analysis, but it is my understanding that it encompassed all net metering customers. Did you actually attend those meetings? I just want to set a foundation and make sure that I understand your role, and so we're clear about what's proper for me to question you on. Sure. Yes, I did attend those meetings. Can we, and if I need to help you here with the exhibits, I'm happy to do that. If you have them in front of you, just let me know. But I can share my screen, and I have it in front of me, the exhibits that are now evidence in this proceeding. Ms. Smith, did you offer these? You did offer the exhibits, not just the testimony, correct?
Ms. Ford's exhibits are in the record as hearing exhibit number 6.
Thank you, Madam Chairman. Ms. Ford, if you would turn to page 21 of Exhibit 1. Actually, let's go to page 18. And just let me know when you're there, please.
Give me 1 second. I'm actually going to pull up a digital version.
Please take your time.
My hard copy, for some reason, printed a couple blank pages, and that happens to be one of them. And you said page 18?
Yes, ma'am. Thank you.
Okay.
What is this document?
Hang tight for me. 1 more second. It's loading slowly for me. Okay. So page 18 of the exhibit. Now, are you looking at the header 18 or the page number from the stamp from the commission?
when I give a page number, it will be the actual pagination number of the exhibit. So what I'm looking at is for Direct Exhibit 1, and right under that it says page 18.
Okay, perfect. The agenda?
Yes, ma'am. So the question on the table is this partly an agenda for what was discussed at the stakeholder meetings?
At the first stakeholder meeting, yes.
The one that took place on March 12th?
That is correct, yes, sir.
And this document references that residential rate design was discussed. Non-residential rate design was not discussed, was it?
In that particular element of the agenda, I would agree that that is just residential rate design.
Are you, do you have an area of expertise that would allow the Commission to better understand how rate design is different for residential and non-residential, or are those questions better posed to someone else?
I have an understanding, but probably enough to be dangerous, so I would pose that to somebody else. Yes.
Yes, ma'am. I'll do that. Okay, next page, page 19. That confirms here that what was discussed at these stakeholder meetings was residential rate design and not non-residential rate design, correct?
Again, for that component of the agenda, yes, that is residential rate design.
Okay, in a moment I'm going to ask you to point to me where commercial and industrial rate design was discussed. But before I get there, did you happen to hear Mr. Brown's testimony yesterday?
I did.
Do you remember him testifying that Act 62 requires the Commission to consider all sorts of things without any sort of distinguishing between rate classes, i.e. residential and non-residential?
Yes, he testified that Act 62 in its definition of customer generator does not delineate between residential or non-residential.
And he also testified that Act 62 requires the Commission to approve a solar choice tariff for both residential and non-residential customers, correct?
That is correct, but I would note that that's a different section of Act 62 than what is being discussed today in the generic docket.
I think that's a matter of opinion, but either way, Act 62 does provide that. You would agree with that?
There is a section of Act 62 that addresses solar choice tariffs, yes.
Thank you. Okay, page 21, we're talking about cost classifications in this slide deck. And who is this presented by? Is this Mr. Huber?
I believe this is Lon Huber that did this. That's correct, yes.
And Mr. Huber is a witness for Duke in this proceeding, correct?
He is, yes, sir.
All right, so cost classifications, this is page 21. Where are non-residential cost classifications discussed in this slide deck?
This is not my slide, so I would defer to Mr. Huber on this.
Well, but you can use your eyes to determine whether or not non-residential cost classifications were discussed here, and you were at the meeting. Please answer the question.
I think in general, rate design, regardless of residential or non-residential, can include components such as energy, customer, and demand classifications. So I mean, I think that's basic utility rate design, regardless of residential or non-residential, which is my understanding is this what the slide presented. It was an educational tool for stakeholders to understand the various ways that utilities design and how they recover costs, regardless of customer class. So I would argue that this does, even if the title of this section was residential, these are basic utility rate-making components that apply to all customer classes.
Mr. Spear, are you with us? Mr. Spear, can you hear us? Can y'all get him on the chat?
Madam Vice Chairman, I apologize for that. As if we didn't need any additional technical problems, our phone lines yesterday and today were very troublesome, so I'm just getting kicked off. But I'm on my cell phone now. I'm ready to go, and I apologize.
It's okay. Thank you.
If you would just tell me, Ms. Ford, whether or not residential cost classifications are represented on this slide.
Residential and non-residential cost classifications are presented on this slide.
Where are non-residential?
It's basic utility rate design, that there are energy, customer, and demand components. And I think if you would look at the non-residential customer tariffs and rates, you would see these elements. Demand is typically an element that is not in residential customers, but is in non-residential customer rate design.
And on page 22, Mr. Huber has provided a graph for typical residential rate design, correct?
That is correct.
And on page 24, in the meeting on March 12th, it was discussed cost recovery structure favors for NIM customers. And again, we're talking about residential cost of service in this slide, correct?
I believe in this one that is specific to residential, and I do know the large majority of the data is on the residential side, which is potentially why this was presented for residential, because we have the data, but I would defer to Ms. Huber on that.
In what capacity was non-residential commercial and industrial customers discussed at any of these meetings?
I think a lot of the discussions, especially in the first meeting, was very high level, just looking at what the Act required, which would be for all customers, and looking at the data that Duke was providing, as well as different elements that Vote Solar and Sunrun, for example, provided. It was also looking just at industry benchmarks throughout the country as what's going on in net metering in general, which would be residential and non-residential. So I would say that it was woven throughout the conversation.
But more specifically, I mean, that's general. Do you recall anyone actually saying anything related to either data, rate mechanisms, policies in these two meetings related to non-residential customer generation?
I'd have to look back through the meeting minutes, but I not off the top of my head.
You haven't provided the commission the meeting minutes, have you?
Yes, sir, they're in my exhibit.
The actual minutes from the meeting?
Yes, sir.
Page?
Sure. The meeting minutes for the first stakeholder meeting is, let's see, I apologize, I scrolled past it.
I've got them here. I can help you out.
It is page 3 of Exhibit 1, and then for meeting number 2, it is Exhibit number 2, and it is page 3 as well.
Okay, please tell the commission and these meeting minutes were consideration of non-residential elements that would be relevant to this proceeding were discussed.
Let's see. Since I'm currently on the second meeting, I think if you look at calculating the value of DER, Mr. Grinstead from Sunrun discussed potential direct and indirect economic impacts that would be relevant to all customer classes. Jason Martin with Duke Energy discussed the value of DER according to Act 236, and that applies to residential and non-residential customers. There was a discussion of how to evaluate the direct and indirect economic impacts. Those are nationwide benchmarks. I would say that is relevant. Successor tariff and rate design, those were high-level concepts. It was not specific to residential or non-residential. And those were concepts, things that we've seen elsewhere, so that would apply. And then let me go back to the first meeting, so I can reference those minutes.
That's page 3, Exhibit 1.
Okay. Let's see. Overview of Act 62 and net metering. That would apply to both residential and non-residential because, as you said, Act 62 does not delineate the difference between the two. The stakeholder process, of course, that was just discussing how we anticipated things going. Looking at long-run marginal cost of service implications of customer generators. Customer generators, as we've said, would be residential and non-residential customers. And let's see, T&D planning. There's transmission and distribution for all customers, and so I would say that is relevant as well. So based on the meeting minutes, I would say all of the meetings, both 1 and 2.
Okay. Would you dispute the fact that a word search in your testimony, which includes your exhibits, a word search for non-residential does not generate any hits?
I'd have to defer. It seems like you've done that search. I have not.
Would you dispute the fact that a word search for the word industrial does not generate any hits in all of your testimony and all of your exhibits?
Again, I'll do you. It seems as if you've done that. I would note that mine was about the broad stakeholder process and not necessarily the specific details of discussion. That is why we included the minutes. So I would not be surprised if specific terms like that, similarly specific terms like demand or energy or things like that wouldn't appear in my testimony, even though they apply to all customer classes.
And you agree that the slide deck for both of those meetings is attached to your testimony as an exhibit?
That is correct.
Would you dispute the fact that a word search for the word commercial appears one time in all of your testimony and the slide deck exhibits, and it's a part of Vote Solar's presentation?
I don't know that. Again, customer generator is a broad term. Net metering is a broad term that we being Duke, considers that encompasses residential and non-residential. And so I'm not surprised that there wasn't a delineation, considering that the companies recognize that being a broad term that encompasses all customer generators, not just residential.
Respectfully, I don't believe that the question that I asked was answered, and it is, would you dispute the fact that a word search of your testimony and exhibits shows that the word commercial appears one time?
Again, I'll defer to you as if you've done that search, and I have not.
The public notice that you referred to was published in the Docket, not published in a newspaper or any other forum that's widely read, correct?
Correct. It was published in the Docket, which for those following along in the industry, I would say is better than a newspaper.
Even in a docket in which a body that has been designed to monitor regulatory affairs for the solar trade, i.e. the South Carolina Solar Business Alliance, is not an intervener in that proceeding?
You don't have to be an intervener to follow the dockets. In fact, you can sign up on the Commission website for notices of different dockets. So you don't have to be an intervener. Anyone in the public can access DMS.
Final question. Did Alder Energy Systems provide any feedback relative to these collaborative stakeholder meetings?
Alder Energy did subsequently in September reach out to Duke, and we did meet with them and walk them through some of the items from the stakeholder meeting, and we did receive feedback. So we have been in contact with Alder. As I said, once we were aware that they were interested, we've had several conversations with them. So I would say yes, they have provided feedback.
Has any of that feedback been implemented in Duke's testimony and what Duke has asked this commission to do?
their feedback was not relevant to this docket. So I would say no.
No further questions. Thank you.
Thank you, Mr. Spear. Office of Regulatory Staff?
Jenny Pittman for ORS. We have no questions for this witness.
Thank you, Ms. Pittman. Commissioners, questions? Commissioner Williams.
Thank you very much, Madam Chair. Ms. Ford, I am looking at the bottom of page 6 in your testimony regarding the 4 elements that came out of the workshop.
Commissioner Williams, could you get a little closer to your microphone?
Yes, and I can do that as well. Would you like me to start over, Ms. Ford?
I believe I heard on page 6, is that correct?
Right, right.
Great.
It discusses 4 key elements that came out of the workshop. And the one I'm curious about understanding more about is the impact, what the thought was behind consider locational specific incentives for customers when connecting to the grid. Can you give me some more background on what that thought was?
Sure, I will start, but I will defer to another witness to give more specific details. Okay. But my understanding is within the grid, there may be elements where it is a very good thing or potentially a counterproductive thing to have a distributed energy resource. There may be grid congestion in one location and significant upgrades would be required to put additional distributed energy resources at that location. Conversely, there could be really great opportunities where there's a great benefit to the companies as well as its customers to have a distributed energy resource in a particular location. The grid is more accepting of that distributed energy resource. And my understanding from this, and again, I would defer to one of the internal Duke experts, is that there should be considerations if there are really, really great benefits to the utility and its customers for putting a distributed energy resource in a certain location, that potentially that customer installing it should receive the benefit that the company and its customers are receiving.
Thank you very much. I appreciate it.
You're welcome.
Any other commissioners? Ms. Smith, any redirect?
Yes, Madam Vice Chairman, very brief. Ms. Ford, do you recall when Mr. Spear was asking you about the stakeholder engagement meetings and who attended?
Yes, ma'am, I do.
And if I were to go to your Ford Direct Exhibit 1 on page 5, what would that show? Can you get there?
I sure can. That is the list of attendees for the first stakeholder meeting and the organization that they represent.
Okay. And so this is a list of attendees. The invitee list was broader, correct?
Yes, it was much larger.
And do you see commercial entities listed on this list of attendees?
I do, as well as organizations that represent industrial and commercial customers.
Okay, thank you. And if I go to your Exhibit 2, page 4. Are you there?
I'm getting there. Yes, ma'am, I'm there.
Okay. Would you see attendees on this list as well?
That is correct. These are the attendees for the second stakeholder meeting.
And if I understood you before, the invitee list would have been broader.
It was. In fact, it was broader than the first meeting because additional stakeholders were added by participants from the first stakeholder meeting.
Okay. And do you believe, and is it your understanding or belief that these 2 lists of attendees and the broader group of invitees represent a good faith effort for Duke to take on stakeholder engagement?
I definitely think it represents a good faith effort, and I think it was representative of all the interested stakeholders.
Thank you. No further questions.
Thank you.
Thank you, Ms. Smith. I'm forgetting to turn the microphone on. Any recross on those, on the limited questions asked on redirect? I'm not gonna go through the list. Speak up.
Oh, that was a question? Correct. I would ask for permission for one question with respect to the list on page 5 and one question with respect to the other list from the other stakeholder meeting. That's all.
Please proceed.
Thank you. Ms. Ford, I'm on page 5. A solar developer focusing on C&I customer generation in the state of South Carolina is not on that list, correct?
I don't see a developer.
Same question with respect to the second list, or the second meeting that occurred on April 23, and that is on your Exhibit 2, page 3.
That I would disagree with you on that one. SIA is on that list, and SIA states that their members include developers for retail, commercial, and industrial installations. So I do think that they are represented.
They may be represented, but that doesn't answer the question. The question was, on that list, is it true that no C&I developer focusing on customer generation in the state of South Carolina was an attendee?
An organization representing C&I developers was, but a particular developer, no.
Thank you. Nothing else. Thank you.
Thank you. Ms. Ford, commissioners, any limited recross or any questions? Thank you. Thank you, Ms. Ford. You may step down. Ms. Smith, please call your next witness.
Madam Chair, this is Ashley Cooper for Duke Energy. I'll actually be calling the next witness for Duke Energy, and at this time the companies would like to call Dr. Julius Wright.
Mr. Cooper, we're having difficulty hearing you. Can we do a sound check with you? Can you talk to me for a second so we can see where we are?
Yes, Madam Chair. Testing 1, 2, 3, 4, 5.
I think that may have it. Is that producers in the back? Is that sufficient? Okay. Thank you, Mr. Cooper.
Thank you.
I think we're good. Thank you, Madam Chair. I do have somebody that just walked in from our technical supports. If we need, if there's any issues, just let me know. I'll be happy to make adjustments. Good morning, Dr. I call Dr. Julius Wright.
Dr. Cooper.
Madam Chair.
Wait a minute, just a second.
If I could swear.
Let me say this. Dr. Wright, would you please state your name and for the record?
Julius Wright.
Thank you. Please you'll be sworn by the court reporter now. Thank you.
Dr. Wright, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Please proceed.
Thank you, Madam Chair. Good morning, Dr. Wright.
Mr. Cooper, Mr. Cooper, we're losing you again.
Okay. Let me try one more time. I don't know what the issues are.
I don't know what, but that's good right there.
Okay. I will try my best not to move. Okay. Good morning, Dr. Wright. Please state your name for the record.
Julius Wright.
By whom are you employed and in what capacity?
I'm the president of J.A. Wright & Associates.
Did you prepare or cause to be prepared 20 pages of direct testimony that were pre-filed with the commission in this proceeding?
Yes, I did.
Okay. If I asked you the same questions that were asked in your pre-filed direct testimony this morning, would your answer be the same?
Yes, they would.
Madam Chair, I would ask that Dr. Wright's pre-filed direct testimony be entered into the record as if given orally from the stand.
Dr. Wright's pre-filed direct testimony will be entered into the record as if given orally. Thank you.
Dr. Wright, did you also prepare or cause to be prepared 2 exhibits that were attached to your pre-filed direct testimony?
Yes, I,
Do you have any changes to those exhibits at this time?
no, I do not.
Madam Chair, I would ask that Dr. Wright's pre-filed exhibits be entered as the next composite hearing exhibit. I believe that would be hearing exhibit number 7.
Dr. Wright's pre-filed exhibits will be marked for identification, a composite exhibit, and entered into the record as hearing exhibit number 7. Thank you.
Dr. Wright, did you also prepare or cause to be prepared 17 pages of rebuttal testimony that were pre-filed with the Commission in this proceeding?
Yes, I did.
If I asked you the same questions that were asked in your pre-filed rebuttal testimony this morning, would your answers be the same?
Yes.
Madam Chair, I would ask that Dr. Wright's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Dr. Wright's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand. Thank you.
Madam Chair, at this time, we will walk through Dr. Wright's summary in a Q&A format.
Please proceed.
Dr. Wright, what is the purpose of your direct testimony?
The purpose of my direct testimony is to discuss the ways in which an economic analysis is performed in order to determine the direct and indirect economic impacts of a program, which are a component of the cost-benefit analysis of the existing net energy metering programs that is required by Act 62. Although I did not provide an actual analysis of the direct and indirect economic impacts due to lack of certain relevant information, the principles set forth in my testimony are generally applicable to any cost-benefit analysis of net energy metering programs.
How do you recommend that the Commission evaluate economic impacts in the net energy metering context?
When evaluating the economic impacts of net energy metering, it is important to set accurate definitions of terms so that all parties are aware of what is being discussed. I recommend defining direct impacts as the immediate results of the direct expenditures related to a certain activity, whereas indirect impacts typically represent the increase in economic output from the various industries whose output is impacted by the industry affected by the direct impacts. There's also a third economic impact known as the induced economic impact, but including such impacts in a cost-benefit analysis will either lead to additional cost or benefits. Further, it is important to determine how you will use the economic impacts in your evaluation. Based on my experience, economic impacts have only been used in a qualitative manner when evaluating net energy metering programs, rather than in a quantitative way.
Are there any other considerations you would recommend?
Yes, it is also important to consider how you want the economic impact analysis to be conducted and to consider all of the issues that need to be resolved in undertaking such an analysis. The two models that are typically used by economists for examining the economic impact of net energy metering are the implant and JEDI models, which are both input-output models. My direct testimony discusses in great detail the key items that must be accounted for in a proper analysis of economic benefits, which include things like recognizing sound economic principles. Additionally, because both the implant and JEDI models report gross economic impacts rather than net impacts, these models must incorporate consideration of the but-for alternative expenditures or the foregone economic opportunity cost after the analysis is complete, which will result in a reduction of the gross economic benefits related to the net energy metering program. Including this but-for option in an economic analysis is critical, given that omitting this aspect would surely provide an inaccurate evaluation to the Commission.
And how do other states view these issues?
In my testimony, I provide the Commission with a survey of other states and corresponding analysis of economic impacts. Importantly, I found no state that used economic impacts in a quantitative fashion when setting rates. In fact, the state of Florida has completely rejected the consideration of such impacts in the rate-making process. As such, the Commission should exercise caution when considering economic impacts arising from net energy metering programs, especially since no other utility commission has apparently quantitatively applied any estimated economic impacts of net energy metering to their state's net energy metering tariffs.
What is the purpose of your rebuttal testimony?
The purpose of my rebuttal testimony is to address the testimony of several interveners to provide a view on how the information presented in the docket could be used in future proceedings.
And what did you take away from the direct testimony submitted in this docket?
It is clear from the direct testimony filed in this proceeding that the issue of economic modeling of direct and indirect economic benefits is not a straightforward exercise and will require great care. It is also clear that while the witnesses discussed a number of theoretical issues, they do not address how the economic considerations will be incorporated into and impact the design of the net energy metering, cost-benefit analysis, and the future solar choice tariffs. I agree with ORS witness Ori's testimony on several points: that indirect economic benefits should not be included in the primary valuation of net energy metering. Number two, that the Commission could use evidence of positive statewide economic benefits to support a solar policy. Number three, that indirect economic benefits should be taken on a qualitative basis. And four, that increased customer solar would, in the long term, result in an economic decline due to higher electric rates. However, I do have concerns with OR witness Ori's opinion that indirect economic benefits could be used in the consideration of the trade-offs between eliminating cost shift and the attempt to avoid disruption of the DER market, because the quantification of such benefits is extremely controversial. I respond to the statement made by witness Barnes, who testified on behalf of Solar Energy Industries Association and North Carolina Sustainable Energy Association, that Act 62's requirement to avoid disruption of the private DER market means that the Commission must adopt cost-shifting policies in order to provide subsidies to the solar industry. While Act 62 does contain a mandate to avoid disruption of the private DER market, it also contains a possibly conflicting mandate to reduce the cost shift caused by the net energy metering programs to the greatest extent practicable. I do not believe the Commission should assess the forward-looking benefits of DER. There is no reasonable way for the Commission to implement witness Barnes' recommendation because any benefits of future technologies are purely speculative. Finally, I discussed several shortcomings in the economic modeling of witness Hefner, who testified on behalf of various interveners in this docket. Specifically, his economic modeling of the direct and indirect and induced economic impacts. First, it is impossible to reconcile employment data that witness Hefner used. However, it appears that the estimate of the number of South Carolina-based jobs created by the solar industry was incorrect, and some North Carolina jobs may have been credited to both South Carolina and North Carolina, thereby being double counted. Second, his modeling fails to adjust the gross economic impacts to provide the net economic impacts, and could therefore convey an incorrect conclusion by inflating the actual economic impact in favor of the solar industry. Third, his study does not account for the cost or cost impacts of solar incentives, such as tax incentives paid to promote solar adoption, that could cause other government programs to go unfunded or could cause a tax increase. Finally, his study assumes without sufficient proof that solar energy is a direct substitute for fossil-based electric generation and makes no mention of the related costs that would be required to make solar a true economically substitute for fossil-fired generation resources, but has not offered sufficient proof indicating that solar is an economically efficient alternative to fossil-fired resources. The errors cause witness Hefner's study to overstate any economic benefits, and it actually may understate potential economic harm.
What conclusions are you able to draw upon your review of the testimony submitted in this docket regarding the incorporation of economic impacts in these studies?
Taken together, the testimony submitted by the other parties in this docket evidences support for the positions I set forth regarding the difficulty in quantifying economic impact. The areas of disagreement, in my opinion, simply reiterate the difficulty in utilizing such an imprecise measure in the rate-making process, which requires quantifiable, evidence-based approaches. As such, I believe that if the Commission utilizes these impacts at all, they should be confined to offering qualitative guidance related to the value of projected solar installations under net energy metering, rather than impacting the rates thereunder. And this concludes my testimony summary.
Thank you, Dr. Wright. Madam Chair, the witness is available for questions at this time.
Thank you, Mr. Cooper. Dominion Energy, any cross?
No cross for this witness.
Thank you. South Carolina Appleseed Legal Justice Center.
No questions for this witness. Thank you.
Nucor Steel.
No questions, Madam Chair.
Vote Solar.
No questions. Thank you.
North Carolina Sustainable Energy Association.
No questions, Madam Chair.
Solar Energy Industries Association.
No questions, Madam Vice Chair.
Upstate Forever CCL and SACE.
Yes, we do have a few questions for this witness.
Please proceed.
Thank you. Good morning, Mr. Wright. This is Kate Lee. So your rebuttal testimony critiques Dr. Hefner's economic impact analysis in part because his study didn't account for costs or opportunity costs. Is that correct?
Yes, that's what we refer to really as what I refer to as a but-for option in developing the net economic benefits as opposed to the gross benefits.
Thank you. Dr. Hefner, in his study, he used an economic model called IMPLAN to conduct his analysis. That model does not account for costs or opportunity costs. Is that correct?
That's correct.
IMPLAN is widely used to evaluate economic impact of various policies. Isn't that correct?
That's correct.
Mr. Wright, are you aware that Duke Energy itself has submitted the results of IMPLAN analyses to this commission on more than one occasion?
I would not be surprised.
Okay. So, I guess, are you familiar with a report that Duke commissioned from Dr. Joseph Van Nessen titled The Economic Impact of Duke Energy, which Duke filed with this commission as an allowable ex parte material in docket number ND-2018-15-E?
I'm not familiar with that, but I just don't recall if I've seen it.
Okay, well, so you're not aware that in that report, Duke itself used IMPLAN to calculate the statewide economic impacts of its Power Forward Grid Improvement Plan in South Carolina?
I'm not aware of that, but let me be sure we're talking about the same thing. IMPLAN can be used to perform two analyses, one looking at the gross impacts, and then you do the but-for analysis and you subtract the two. So the fact that IMPLAN provides gross impacts, it can provide gross impacts for two different alternatives. And that's how you have to look at it to get to the net economic impacts using the IMPLAN model.
Very well. So then, I guess, would you be surprised then to learn that in the Duke rate case, in particular, I'm talking about docket number 2018-319-E, that Duke used its IMPLAN results as part of the cost-benefit analysis that it conducted for its grid improvement plan?
I just don't recall that. I'm not saying they didn't. In fact, I've used an input-output model myself for for Duke in a study, but I produced the net economic benefits.
Interveners in this case have also put forth comprehensive testimony on valuing the costs and benefits of solar. Is that correct?
Yes, they put forth testimony. I'm not sure. I may characterize it different, but I would accept your characterization.
Very well. So interveners have not said that Dr. Hefner's testimony is the only metric to be used in evaluating the costs and benefits of solar. Isn't that correct?
That's correct.
Very well. I'll move on. Dr. Wright, I'd like to reference the discussion on pages 10 and 11 of your rebuttal testimony regarding Dr. Hefner's use of data from the Solar Foundation National Solar Job Censuses. You stated that the data from those reports should concern the Commission as being likely biased, but you did not provide any evidence that the Solar Foundation censuses are biased. Isn't that correct?
Well, that's not entirely correct, no. First, if you'll point me to the exact line where I say it's potentially biased.
Sure, give me one moment. That would be line 16 on page 10 of your rebuttal testimony.
Yes, and it's self-evident to me if you're getting numbers from an association that's the Solar Industry Association that is potentially biased. I did not say it is biased. I said it's likely biased. If you go back to my first testimony, my original direct testimony, in Exhibit 2, I present a survey of several states. And on the first page of that Exhibit 2, I discuss the state of Nevada. And in 2016, in a 2016 order from the state of Nevada, they discuss where the solar industry was arguing that they would lose 6,000 jobs with a net energy metering tariff that was not designed according to, I guess, what they would prefer. And it was the same source that was used in the South Carolina study that Dr. Hefner did. And quoting the Nevada study, or quoting the Nevada order, they found the information and testimony presented by the staff regarding the employment figures for Nevada's solar industry indicates that the figures cannot be reasonably relied upon as an estimate of the number of solar jobs in Nevada or the number of jobs that could potentially be impacted by this order. So I did provide some evidence that another state had looked at the job and employment estimates of this same group and said that they could not rely upon those job estimates. I also presented evidence where I tried to go back and correlate the number of jobs that he was quoting and the source that he used. And when I looked at that source and looked at all the backup data, as I say in my rebuttal testimony, there are jobs that they relate to the Charlotte-Mecklenburg area and Gastonia, and it's approximately I don't know the exact number. I could probably find it in my rebuttal testimony. It's approximately 1,400 jobs, and that's in the Charlotte-Mecklenburg Gastonia area. And when you look at South Carolina, and that's for North Carolina, when you look at the South Carolina numbers, the same survey, it uses the same 1,400 jobs from Charlotte and the Gastonia area. So I don't know if there's double counting there or not. I'm just saying that you need to be very careful that I'm not sure that I would agree that this is the exact or correct number of jobs.
Very well. Well, okay, let's talk about that double counting issue that you raised in your rebuttal testimony. You stated that you couldn't confirm nor deny whether it double counted jobs between North and South Carolina, and you pointed to that Charlotte metro area. Are you aware that the Solar Foundation report also breaks down solar jobs by county and not just by metropolitan area?
I'm not aware of that, but I looked all over their website to try to confirm the number of jobs, and I couldn't get the backup data. Maybe you could find it. I just could not. And I've spent a great deal of time trying to find it. Because like I said in my rebuttal, I couldn't confirm or deny it.
Very well. So, Mr. Wright, to confirm, you did not view the data, the state data for South Carolina that is broken down by count at the county level on the Solar Foundation website, and that is publicly available and was cited in Dr. Hefner's testimony.
No, okay, ma'am, but I can tell you I looked all over their website, and I would love for somebody to show me where it is easily accessible, because I tried to find it by county or a little better data, and I couldn't find it.
Okay, so you did not verify whether, if you had added up the jobs in all the South Carolina counties, whether they matched the numbers for the state, because you didn't view that data. Is that correct?
I couldn't find it. I could not find the county, so you're absolutely correct.
Okay. Duke would be familiar with solar companies operating in its service territory in South Carolina. Isn't that correct?
I have no reason to dispute they wouldn't be. I just don't know. I've not asked that question.
No. And Duke, in its testimony, did not conduct its own evaluation to verify the number of solar jobs in South Carolina. Isn't that correct?
I did not see that. You're correct.
And Duke, in its testimony, also did not conduct its own evaluation of the economic impact of net metering to South Carolina. Isn't that also correct?
That's correct.
Just one last question, Dr. Wright. On page 9 of your responsive testimony, you testify that the commission should consider what you term net economic impacts. Could you direct me towards where in the Energy Freedom Act that direct and indirect economic impact is defined only as net economic impacts?
The Act does not discuss either the gross or the net impacts, but if you do these studies, and I've done a couple of them and I've seen a number of them, you always recognize, and as I said, other states, if you look in my direct testimony, I discuss other states. In my rebuttal testimony in particular, I point out 3 or 4 different examples where other states, including North Carolina, they actually did a study and reported the gross economic impacts in North Carolina, but that study, which was done by the Research Triangle Institute, they admitted that they did not look at the net economic benefits, which would have done the but-for analysis that I said is required to provide a full and complete picture of the economic benefits.
Well, thank you, Dr. Wright. No further questions.
Thank you, Ms. Lee. Alder Energy Systems.
Thank you, Madam Chairman. I'm on speakerphone. Just want to make sure that everyone can hear me okay.
We can hear you at the commission.
Dr. Wright, are you able to hear me?
Yes, I can hear you.
Thank you. You discussed jobs in Nevada after the commission there changed its NIM policies in your testimony, correct?
Put that in my direct testimony, yes, and discussed an order from Nevada.
Do you know what ultimately happened to those jobs?
I have no idea what happened to those jobs.
Would it surprise you to learn that Solar City closed its doors in Nevada after this policy took effect?
I have no reason to agree or disagree. I have no idea what.
Madam Chair, this is Ashley Cooper, counsel for Duke Energy. this is outside the scope of Dr. Wright's testimony. He's talking about an analysis and how you perform an analysis to determine direct and indirect impact. This is not about jobs for a particular company. It's not about job increases or decreases since a study was performed. This is about how you set up an analysis and the proper assumptions going into that. So this is an improper line for Dr. Wright.
Mr. Cooper, this is cross-examination to the extent that it may be relevant. We got it. Please proceed, Mr. Spear.
Thank you, Madam Vice Chairman. I have no further questions.
Thank you, Mr. Spear. Officer Regulatory Staff?
Jenny Pittman for ORS. We have no questions for Dr. Wright.
Commissioners? Commissioner Powers?
Thank you, Vice Chair. Dr. Wright, thank you for your testimony, and we're overwhelmed with a lot of material here and a lot of different opinions, and some of this general discussion is kind of hard to take and figure out how we're supposed to come out with an exact methodology, which we're mandated to do. One thing you mentioned, I think you mentioned it generally, was about the tax incentives and how that affects the decisions. Has there been any change in tax incentives that you're aware of in the last year or 2 years, or do you have any further information about how that's going to affect going forward?
Mr. Commissioner, I don't know of any that have occurred in the last couple of years. There were some discussions about some federal tax incentives that may or may not have gone away. I know that some states have adopted tax incentives, others have not. I'm not aware of what's being considered or what may be on the table in South Carolina with regard to tax incentives.
Well, are you aware of North Carolina, anything that you think is different there than here?
No, sir, not now. I think in the past, North Carolina and probably South Carolina too may have had some tax incentives. Where they stand right now, I don't know.
One other thing that you mentioned, and maybe it just went past me, could you explain what you mean by induced impacts?
Yes, sir. The best way to describe it, I guess, is if you start a business or you have a business, you pay your employees and they go out and they spend their money on certain things. And it's within the, say you're in Columbia and you go out to the grocery store and you spend your money. Well, that is a direct impact, economic impact. And they spend, some portion of their salary, so that's all a direct impact. But the grocery store or the gas station or the movie theater or whatever it may be, assuming movie theaters, are allowed to finally get opened back up, they employ people too. And so the people they employ are paid salaries, and they go out and spend their money. And those employees in those businesses like the supermarket or the gas station or whatever, that's the induced effect, because that money circulates in the local economy for some period of time and keeps providing a positive economic impact going forward. It's not a direct impact, but it's because of the expenditures of the local company that these other businesses also are able to provide an impact to the local economy.
Okay.
Does that answer your question?
Go ahead.
Does that answer your question? Is that?
I guess what I'm trying to understand is how induced impact affects directly a rate or a solar user of power, and how if at all we can quantify that, and I guess we can't, can we?
No, we can. What in the in-plan model, they have two types of multipliers. They call them a type 1 and type 2 multiplier. The type 1 multiplier is used to determine what are the direct and indirect economic impacts. But then those other additional impacts called the induced impacts, you can discern those from what in-plan calls their type 2 multipliers. So they do have a way to calculate that. It's somewhat interesting that it was not included in Act 62. I assume it was for a purpose, and possibly because the induced impacts are what I will call a little more squishy. They're not as easily calculable or proven, say, as the direct impacts. Because with direct impacts, you know how much employees are getting paid. With induced impacts, you don't know how that employee's expenditures are really siphoning out through the economy and increasing the economic activity throughout the region's economy.
So as far as these induced impacts, that would be what you, I think, talked about, the failure to identify economic opportunity costs, or is that just cost rather to the industry itself?
I'm sorry, induced impacts would be what? I didn't catch your. I couldn't quite hear.
Somewhere in your testimony, I just recall, and I'm taking this straight from here, you talked about foregone economic, foregone opportunity costs. That is not dealing with induced.
Well, it could, and let me explain. Usually you have three types of economic benefits or costs: direct cost, indirect cost, and induced cost. And you do an analysis, and for example, the analysis would be that a company is going to leave the Columbia region, and you analyze, well, what will that impact be? And you can look at the gross impact. But what you really want to know is the net impact. In other words, if the company stays or goes, you want to know the but for. Or if a company wants to move in and they hire new employees, well, it may be that investment could be made in something else. For example, somebody wants to either start a gas station or a laundry, and you want to know, well, which one has the most economic benefit, so you compare the two alternatives. So that's the sort of the but-for analysis I'm talking about.
Thank you, sir.
Commissioners, anybody else?
Madam Chair.
Excuse me, Commissioner Thomas, I'm sorry.
Thank you. Dr. Wright, appreciate you being here and helping walk us through some of this stuff today. There's been a lot of talk about the but-for option, and the fact that was left out of the analysis that Mr. Hefner did. And
Service Department. We were calling about your vehicle's manufacturer's warranty.
All right, I think we've probably gotten past that. In any event, the but-for option, do you have an opinion as to how that would, if that were taken into account, that would change or the overall economic analysis?
Well, invariably, when you look at what we call the but-for option, and you try to get what are the net economic benefits as opposed to the gross, invariably the net benefits are always smaller than the gross benefits, because you're looking at an alternative. And in fact, in my rebuttal testimony on page 13, I quote an Arizona solar impact study, and let me quote what it says there. gross studies clearly produce higher estimates of the economic impacts of solar enhancements than net studies. And the gross studies only consider the direct positive impact of increased economic activity in a specific sector, whereas net studies represent a more thorough form of economic modeling, as they also account for the trade-off of the economy, which result from incentivizing one specific sector. So invariably, the net benefits are going to be smaller than the gross benefits. Whether the net benefits become actually negative, I can't say. It just depends on the analysis. But sometimes when you do the analysis, the gross benefits looks like you're adding 3,000 jobs, and then when you do the but-for analysis, you find out, well, I actually added 3,000 jobs here, but lost 28 or 3,800 jobs over there. So the net economic benefit was actually negative as opposed to positive.
Okay, thank you. That's all I have.
Okay.
Any other commissioners? Thank you. Mr. Cooper, any redirect?
Yes, Madam Chair, but I'll be very brief. Dr.
We need to up your volume, or you get closer, or drop down again.
Thank you, Madam Chair. Is this better? Can you hear me okay now?
That's a little better. We're getting there. Go ahead.
I think my system might have to warm up over here. Maybe a little too
Yeah,
bad.
you're getting better.
Thank you, Madam Chair. Dr. Wright, I just have two questions. Regarding the M-Plan modeling system, use of the M-Plan modeling system does not preclude a but-for analysis, correct?
That's correct.
In other words, a but-for analysis can be done in conjunction with use of the M-Plan modeling system.
Yes, and it usually is.
Okay. Thank you very much, Dr. Wright. Madam Chair, no further questions.
Thank you, Mr. Cooper. Any recross on that limited redirect? Please speak up. Hearing none, Dr. Wright, thank you for your testimony, and you may be excused.
Thank you.
Ms. Smith, at this point, is this where we're going to allow to take some other witnesses out of order?
Yes, Madam Chairman.
Okay, thank you very much. Okay. We're going to take a short, let's break, give our court reporter a break here. Let's be back at, can't even see let's see what the clock says. 10:50. Please be back at 10:50. Thank you very much. thank you. We are back from our break. I understand we've had to redo some microphones here, so hopefully I will not be reverberating when you hear me. Let's take an appearance, roll call of the commissioners. District 1. District 1.
Commissioner Williams is present in the hearing room.
Thank you. District 3.
Caston present in the hearing room.
District 4. Commissioner, you're not, we can't hear you. Ready? District 5.
Thomas is present in the hearing room.
District 7.
Commissioner Powers is here in the hearing room.
Vice Chair Balser from District 2 is present, and our District 6 chairman is on military leave. And now we are moving to a couple of witnesses out of order. Who will be presenting on speech?
Thank you, Madam Chair. That would be me, Thad Cully, for Vote Solar.
Thank you, Mr. Cully. Please call your witness.
Thank you, Madam Vice Chair. Is with our appreciation of the flexibility of the parties that Vote Solar, the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, the Solar Energy Industries Association, and the North Carolina Sustainable Energy Association call witness R. Thomas Beach to the stand.
Okay. Mr. Beach, please state your name for the record.
My name is first initial R. Thomas Beach, B-E-A-C-H.
Thank you, and please receive the oath from the court reporter.
Mr. Beach, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Colley, please proceed.
Thank you, Madam Vice Chair. Good morning, Mr. Beach. Thank you for joining us. I know it's very early on the West Coast. Could you please state by whom you're employed and what capacity?
Yes, I'm a principal consultant at Cross Border Energy.
And what is your business address, for the record?
It's 2560 9th Street, Suite 213A, Berkeley, California, 94710.
Mr. Beach, did you call us to be pre-filed in this docket on October 8th, 2020, direct testimony consisting of 31 pages and 2 exhibits, numbered RTB 1 through 2?
Yes.
And do you have any changes or corrections to your pre-filed direct testimony at this time?
No, not.
And if I were to put those same questions to you today, would your answers be the same?
They would.
And were the exhibits to your testimony prepared by you or under your direction?
Yes, they were.
Okay, Madam Chair, I would like to move Witness Beach's pre-filed direct testimony into the record as though given orally from the stand.
Mr. Beach's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you. And I would also move to have the 2 exhibits attached to the pre-filed testimony entered into the record and identified as the next composite hearing exhibit.
Mr. Beach's 2 exhibits, RTB1 and RTB2, will be a composite exhibit marked for identification as hearing exhibit number 8 and entered into the record of this case.
Thank you. And Mr. Beach, did you also call to be pre-filed in this docket on October 29th, rebuttal testimony consisting of 27 pages?
Yes, I did.
And that rebuttal testimony was prepared by you or under your direction, is that correct?
Yes, it was.
Do you have any changes or corrections to your pre-filed rebuttal testimony?
Not at this time, no.
And if the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
Yes, they would.
And thank you. Madam Vice Chair, I would move at this time to have Witness Beach's pre-filed rebuttal testimony entered in the record as though given orally from the stand.
Mr. Beach's pre-filed rebuttal testimony will be entered into the record as if given orally. Thank you.
Thank you. And Mr. Beach, finally, did you prepare a summary of your direct and rebuttal testimony today?
Yes, I did.
Would you please proceed to provide your direct and then provide your rebuttal right after that?
Certainly. Madam Chair and Commissioners, thank you for this opportunity to appear before you today. In my direct testimony, I propose refinements to the benefit cost methodology for valuing distributed energy resources in South Carolina, consistent with the new requirements of Act 62 and with the evolving best practices in valuing these resources. My testimony provides a brief overview of Act 62 and its provisions relating to distributed resources and net energy metering, including the role of the methodology that the Commission will approve to assess the benefits and costs of net metered solar systems in South Carolina. This methodology will be used to assess the new solar choice tariff that will take effect on June 1st, 2021, pursuant to Act 62. Act 62 makes clear that the Commission should adopt the benefit cost methodology for distributed solar resources. It has 5 key attributes. And they are, first, examine the benefits and costs from the multiple perspectives of the key stakeholders. Second, focus on the exports to the grid from net metered solar systems. Third, consider a comprehensive list of benefits and costs. Fourth, use a long-term life cycle analysis. And 5, encourage distributed solar customers to use time-of-use rates. Act 62 recognizes that the principal stakeholders in distributed solar development are, first, the participating customers who make long-term private investments in these technologies. Second, other non-participating ratepayers. And third, the utility system as a whole. The goal of the regulator in implementing Act 62 should be to balance the interests of all of these stakeholders. The utility industry has long used a set of cost-effectiveness tests to examine the benefits and costs of demand-side resources from these multiple perspectives. I recommend that the methodology adopted in South Carolina should continue to build upon this experience. I explained that the utility cost test and the participant cost test should be the primary tests used in assessing the solar choice tariff. The utility cost test focuses on whether the bills of customers, including non-participating customers, will increase. The participant cost test examines whether investments in a distributed resource make sense for the participating customers who are making those investments. In addition, the Commission should consider the societal benefits of net metered solar in recognition of Act 62's requirement to consider indirect and direct economic benefits from the net metering program. Finally, my direct testimony addresses how the Commission should recognize that distributed energy technologies are continuing to evolve. The advent of storage as a new type of distributed resource gives customers the ability to store the output of their solar generation, allowing participating customers to shift that output to the hours when electricity is most valuable. Other new distributed energy resources, such as smart thermostats and programmable heat pumps, will allow customers to shift their loads out of the most expensive or resource-constrained hours. The essence of net metering will continue to be valuing the power that customers with renewable distributed generation will export to the grid. The appropriate methodology for assessing the benefits and costs of net metered solar resources should focus on the appropriate value that the customer should receive for the electricity that's exported from their residence. My testimony reviews the specific benefits and costs that should be examined and quantified. All of these benefits and costs have been quantified in other similar studies, and as a result, well-accepted techniques are available for the Commission to consider when taking the task. If there's uncertainty about the magnitude of a specific benefit or cost, the default should not be to assign a zero value to that benefit or cost. Instead, the Commission should establish a reasonable value for the benefit or cost based on an examination of several cases that spanned a range of reasonable values for such a benefit or cost. Finally, my testimony discusses how the results of the adopted methodology can be used to make rate design changes that serve to balance the interests of the affected stakeholders, including customer generators, other non-participating ratepayers, and the utility. The types of rate design changes that the Commission should prioritize are, first, those that align rates more closely with utility costs, such as time of use rates. Or, second, changes that continue to allow the greatest scope for customers to exercise the choice to adopt distributed solar resources, such as a minimum bill. Fixed charges or rate designs that apply only to solar customers should be avoided or minimized due to problems with customer acceptance, undue discrimination, and the future potential for customers to bypass the utility system. So that's the conclusion of a summary of my pre-filed direct testimony. Now I'll turn to a summary of my rebuttal. My rebuttal testimony focuses first on the benefit and cost numbers for residential solar presented in the testimony of Dominion Energy South Carolina. I discuss how Dominion fails to consider and quantify all of the benefits and costs of distributed resources that the Commission adopted in order number 2015-194. Act 62 states that all of these benefits and costs should be considered in evaluating the upcoming solar choice tariff. In some cases, such as avoided energy costs, the utility does not analyze the benefits over the full 25-year economic life of distributed solar resources. The utility testimony is silent with respect to other quantifiable benefits, such as avoided capacity costs for transmission and distribution, avoided fuel hedging costs, and avoided costs to reduce carbon. In response, my rebuttal quantifies the full slate of the benefits and costs of distributed solar on the Dominion system today, revising many of Dominion witness Margot Ebert's numbers and providing several benefits that Dominion does not recognize. I then apply the full set of standard practice manual cost effectiveness tests to residential solar on the Dominion system. Figure ES1 on page 2 of my rebuttal shows the results of that analysis. At this time, residential solar on the Dominion system appears to pass all of the standard practice manual cost effectiveness tests. As a result, there is not presently a cost shift from solar customers to non-participating ratepayers, and distributed solar is a cost-effective resource for Dominion ratepayers. There is also a small net benefit for customers who install solar, indicating that the market should continue to grow, albeit slowly, under the present net metering tariff. This result indicates that in adopting the solar choice tariff, the Commission should take care to make gradual, measured changes to the existing net metering structure so that this resource can continue to attract private investment. Finally, there are significant quantifiable societal benefits from distributed solar, including public health benefits from reduced air pollution and from mitigating the damages from carbon emissions. I recommend that a similar analysis should be applied to the solar choice tariffs that Dominion and the other South Carolina utilities may propose in future utility-specific proceedings pursuant to Act 62. Finally, my rebuttal responds briefly to the opening testimony of the Office of Regulatory Staff on a cost of service issue for the Duke Energy utilities and on the possible impacts of solar choice tariffs on low-income customers. With respect to impacts on low-income customers, my testimony recognizes that this is an equity issue that should be addressed in several ways, including expanding access to solar for low-income customers, so that they can become participating, rather than non-participating, customers of today's solar and storage technology. So that concludes the summary of my pre-filed rebuttal testimony.
Thank you, Mr. Beach. Madam Vice Chair, Mr. Beach is available for cross-examination and commission questions.
Thank you. I think these witnesses are representing most of the interveners, but Alder Energy Systems, any cross?
Chairman, thank you. I do have some questions. Mr. Beach, can you hear me?
I can.
Great, thank you. My name is Taylor Spear. I'm in Greenville, South Carolina. I represent Alder Energy Systems, LLC. I'll represent to you that they are a solar developer that focuses on behind the meter for C&I customers. And I mentioned that to sort of frame my questions, that my questions to you are really going to be limited to anything that's relevant to C&I behind the meter. May I please direct your attention to page 29 of your testimony, line 20. And you may not need your testimony to answer my questions, but I just thought it would be helpful for you to have it in front of you. My first question to you, Mr. Beach, is whether or not you agree that the impacts of net metering for non-participating customers, impacts in this case determined by utility costs, is different for a residential customer and a non-residential customer. Do you agree with that?
Generally, yes. I would say some of the impacts are similar, but there are definitely differences, yes.
And the reason that the impacts can differ between rate classes of residential and non-residential are many, and we're going to go through them as you have testified here, but would you agree with me that one of the reasons is that the rates for C&I customers are less typically than they are for residential customers?
Yes, that's often true, and in particular, the volumetric rates that C&I customers pay tend to be lower than what residential customers pay.
Do you agree that C&I customers traditionally export less electricity to their grid from their customer generation?
I think that typically that is correct due to the different load profile of C&I customers.
Explain the difference in the load profile and why that would impact, please, the amount of energy that's exported by a customer generator.
Well, C&I customers, that's a pretty broad category of customers, but in general, for example, commercial customers would tend to be business and using most of their electricity during business hours of the day, and therefore would tend to have loads that peak in the middle of the afternoon, for example, which is a good match, a better match for a solar output profile than a residential customer that peaks in the evening.
And I appreciate that the C&I rate class is rather large and encompasses a large range of potential customers. So if you wouldn't mind giving the commission of just one example, say a manufacturing plant in the upstate that wants to invest in customer generation, in your expertise, what does the load profile look like for that customer compared to the diurnal cycle of solar generation?
Well, obviously it depends on the operations of that customer, how many shifts they have, but generally they would probably tend to have a flatter load profile than a residential customer, and perhaps their electric use would tend to be spread out over more hours of the day if they have multiple shifts.
Thank you. And one other major difference in residential and non-residential solar is that the C&I rate class is billed in a much different way than residential, correct?
Yes, C&I rates tend to have significant demand charges that are difficult for solar customers to avoid.
Thank you. My next question for you is relative to the concept, and correct me if I misstate it, this is your testimony, not mine. But do you agree that the relative level of penetration of customer generation in a market has an impact on the utility's costs to accept the generation?
I mean, are you talking about integration costs? Is that what your question? For example, whether the utility incurs additional ancillary costs to integrate solar resources, that those costs may go up as the penetration increases? Is that your question?
Actually, my question is more broad, and you're familiar with the Act 236 value stack that we've discussed, correct?
Yes.
How does the relative level of penetration of customer-generated solar impact the Act 236 value stack? So you directly on ancillary costs. I would like to broaden that just to all costs that are associated in that stack. Does it have an impact, the relative level of penetration?
It can, although you need to get to pretty significant penetrations of solar resources in order for those effects to start to materialize. I mean, obviously, markets like California and Hawaii and some other states in the West have seen shifts in their load profile due to the significant penetration of solar on those systems today, with the peak load that has to be served with dispatchable capacity shifted to the evening. But you need to get a pretty substantial penetration of solar before those effects start to materialize in a significant way.
Did you listen to Mr. Robinson's testimony when he discussed a projection of C&I customer generation in South Carolina over the course of the next 10 years?
I do believe I was listening to that, although I didn't. I have not looked at his specific numbers.
Do you have? Well, I'll tell you what the numbers were. His testimony was that over the next 10 years, C&I customer generation is expected to expand by only 11.5 megawatts. How do you interpret that data compared with the notion that lower penetration levels do not create exceptional costs for a utility? Are you able to comment on that?
Well, I mean, 11 megawatts is a pretty small amount given the size of the loads in the Carolinas. So I would agree that that's a very modest penetration.
And you understand that it's 11.5 megawatts over 10 years?
I don't, like I said, I have not looked at his numbers. I will accept that that's what his forecast was.
I don't have anything else. Thank you.
Thank you. South Carolina Appleseed Legal Justice Center.
We have no questions for this witness. Thank you.
Nucor Steel.
No questions, Madam Chair. Thank you.
Back to Dominion Energy.
I have a few, Madam Chair.
Please go ahead, Mr. Gissendanner.
Thank you, Mr. Beach, for being here today. My name is Matthew Gissendanner, and I represent Dominion Energy, South Carolina. Can you hear me okay?
I can.
Thank you. I would like to first turn to page 17 of your responsive testimony, and specifically to Table 9. Are you there?
Yes.
And on that table, you indicate that the 25-year levelized rate for exports is approximately 12.7 cents per kWh. Is that correct?
Yes.
Number in the very book. And that these levelized bill savings in this dollars per kWh, does that reflect your estimate of what the utilities residential retail electric rates will be over the next 25 years? Is that correct?
Yes, I assume that they escalate with inflation.
Okay. And then could you also turn with me now to Table 8 on page 16 of your testimony?
Okay.
And there, this is a table that reflects the avoided cost, levelized avoided cost over 25 years. And there, I believe that you indicate that the levelized avoided cost over 25 years are approximately 14.3 cents per kWh. Is that correct?
Yes.
Mr. Beach, a prudent utility would not charge a lower retail rate than its avoided cost, would it?
Well, avoided costs are, by definition, counterfactual costs. So they're costs that the utility never incurs. So I really don't think that avoided costs are relevant to what the utility's costs actually are. I mean, this is just
Mr.
saying
Beach.
that by installing these resources, it's avoiding higher costs.
Mr. Beach, you understand that the company's retail electric rate is a fully loaded rate that includes not only the cost of energy, but also includes transformers, lines, IT equipment, personnel, healthcare, all the costs that are typically included in retail rates. You understand that, correct?
Yes.
And you also testified, did you not, or you submitted testimony in Docket 2014-246E on behalf of the Alliance for Solar Choice?
Yes.
That was the original net metering docket. And
yes.
You understand that in that case, the settlement agreement provided for solar developers for net metering customers to be paid for their power at the company's retail electric rate.
Yes, I believe that's correct.
And do you also understand one of the provisions of that settlement agreement was that because the customers were going to be paid at the way that settlement agreement was able to work was because the customers were going to be paid at the retail electric rate, the difference, the amount above the company's avoided cost, the difference between the retail electric rate and the avoided cost was actually considered to be an incentive that was recovered through the company's distributed energy resource program.
Yes, I believe that's my recollection of how that settlement worked.
And you would agree with me that solar developers would prefer to be paid the company's retail electric rate and not at the company's avoided cost rate. Is that correct? Sorry, NEM customers. I said solar developers. Let me rephrase that. You would agree with me that customer generators would prefer to receive the company's retail electric rate for the energy they produce, as opposed to receiving the company's avoided cost rate?
Yes, and although I think that the reason for that is that it's, solar companies are in the business of selling solar systems to customers, and customers inherently understand the net metering concept of running the meter backwards, and it makes the process of explaining and selling this new technology to customers simpler.
Mr. Beach, isn't the reason that customers prefer to be paid the full retail rate as opposed to the avoided cost rate because a prudent utility would always have a higher retail rate than its avoided cost rate? And customers are interested in being paid as much as possible.
No, I don't necessarily agree that a utility's avoided costs are always below their retail rate. The cost environment of utilities changes over time, and at times, especially when you start looking at avoided wires costs, avoided transmission and distribution costs, and you look at avoided costs for things like avoiding carbon emissions and avoiding volatile fuel prices in the future, those avoided costs, as shown in my analysis, can be significant. And I don't agree at all that avoided costs are necessarily always less than the retail rate.
Thank you, Mr. Beach. Mr. Beach, I want to next turn to some components of your avoided cost benefit analysis in Table H. I first want to look, well, first of all, would you agree with me with respect to fuel hedging, that hedging is a tool to mitigate risk? So with respect to fuel, I might lock in certain fuel costs now to guard against increases in those fuel costs in the future.
Yeah, generally that's a description of what fuel hedging is.
And would you also agree with me that with respect to your table, that avoided energy costs are highly linked to the cost of fuel?
Yes.
Okay. And your avoided energy cost on Table 8 of page 16 is approximately 3.83 cents per kWh. Is that correct?
Yes.
And are you aware that the Commission on by order dated March 24th caused or entered an order that effectively set DESC's avoided cost component of the NEM methodology at approximately 2.86 cents per megawatt hour?
I'm not familiar with that specific order. It's important that this is the 3.8 cents that you just referenced is a 25-year levelized number, so it includes expected fuel cost escalation over the next 25 years. I don't specifically know the time period for the avoided cost that you just referenced.
Okay, thank you. You are aware that the company did have an avoided cost proceeding, correct? Earlier
yeah, I'm aware that. Yes, I'm aware that they have those regular proceedings.
Are you also aware that that is a contested case proceeding with live testimony from all parties, cross-examination, and that it also included a review by a statutory independent third-party consultant?
I accept that that was the scope of that case. I was not involved in it.
Okay, thank you. And your fuel hedge value is approximately, in your value stack, is approximately $3.35. Is that correct?
$33.50 a megawatt hour, or 3.35
I'm sorry,
cents per kilowatt hour?
yes, I'm sorry, $3 3 cents, 3.35 cents per kWh is what I was talking about. Correct. Are you aware that this commission has consistently determined that the fuel hedge value of NEM for DESC is zero because the company does not operate a fuel hedging program?
I'm not aware of that. You know, the reason that the fuel hedge value is significant is because the calculation, a solar resource provides a fuel hedge for 25 years. That's an exceptionally long time. It's far longer than typical utility hedging programs for their natural gas purchases, for example. And it's expensive to hedge the cost for 25 years because you're tying up a lot of money that you could be spending on other investments. And so that's why that number is significant. But it's a fact that renewable resources will give you a hedge for 25 years against because they will displace natural gas purchases over that period of time.
Mr. Beach, you would agree that your fuel hedge value is not just significant, but it is the second highest component of your avoided cost stack. Is that correct?
Yes.
And we talked about the fact that hedging was a means to mitigate risk. Did you calculate a range of energy prices over the next 25 years?
No, what I calculated is the cost to do what renewable energy does, which is renewable energy has no fuel cost. You know, the sun is free. So it basically, you're substituting upfront capital for the need to go out and purchase natural gas over the next 25 years. And I refer you to the picture of Henry Hub natural gas prices over the last 20 years that's in my testimony in Figure 3. And you can see that there's a lot of volatility in natural gas costs over time. And that's what you're avoiding. You're avoiding that volatility when, you know, a hurricane comes through the Gulf and takes out a lot of gas production capability, and you have a price spike for 3 or 4 months, or you have a polar vortex event. That kind of volatility is expensive for ratepayers, and that's what's avoided by renewable resources, where you are investing capital up front and you don't have to pay for the fuel.
Understood, but you're not asking us to take a 3 or 4 month commitment. You have a 25-year levelized cost, and based on your work product in this docket, you can't tell us today the expected range in energy cost in years 10 through 25. Is that correct?
I can't tell you what that number is, but I can tell you what the cost is to eliminate that risk, and that's the value that I've used.
But doesn't the range of energy prices over the 25 years, isn't that necessary for us to determine what the risk actually is? Doesn't that represent the risk?
No. Basically what I've used is the cost to eliminate that risk. And it doesn't depend on what the risk is. I think that, history tells us that the risk is significant given the price spikes that we've seen in the past.
And I want to be clear. You believe, and you would have this commission believe, that the risk is so significant that the company should pay a solar developer 7.15 cents per kWh today. That's the avoided energy rate plus the fuel hedge value. The next 25 years to lock in 3.83 cents per kWh. Is that correct?
Yeah, the reason the cost is significant is because if you were to go out and try to fix the cost of your natural gas supplies for the next 25 years, you would have to set aside a large amount of money to do that you and you'd only earn to make sure you have that money, you'd have to invest it in a risk-free investment like treasuries. Alternatively, you could take that money and I assume Dominion could earn its weighted average cost of capital if it employed that money for something else. And it's really the difference between the risk-free cost of treasuries and Dominion's weighted average cost of capital that dropped that fuel hedge number. And over 25 years, it's a significant cost to fix the price of your natural gas. And that's the benefit that renewables provide by not having to, by avoiding natural gas purchases.
So again, you're asking the commission to order the company to pay almost double what the expected avoided energy is over the 25-year period. Aren't there hedging instruments that would cost nothing because you give up the benefit of pricing going down in exchange for prices going up, in exchange for giving up the benefit of prices going up? For instance, a costless collar, where I give up my upside and eliminate my downside?
I don't think you can get those for 25 years. I mean, you may be able to get to do a collar for the next 2 or 3 years, but I'm not aware that you can do that for 25 years in the financial market.
Thank you. The next, I have two more issues. With respect to you in your testimony, you use a solar capacity contribution of 34%. Is that correct?
Yeah.
I believe it's on page 8. And are you aware that the commission, by order 2020-244 in March, adopted 11.8% as calculated in that docket by ORS witness Horry, who is also a witness in this docket, as the solar capacity factor to be used in determining avoided capacity costs?
Yes.
And so did you just choose to ignore the commission's finding that 11.8% was the correct solar capacity factor to be used in determining avoided capacity costs, so that you could use your own 34%?
Well, I think that the issue, as I understand it, is basically whether you want to emphasize summer peaks or winter peaks in Carolinas. And so my view on that is that you need to because you can have peaks in the winter as well as the summer, it's important to look at a longer time horizon so that you start to capture the frequency of and duration of summer peak versus winter peak. And that's what I tried to do with my 5-year peak capacity allocation factor analysis. And so it does produce a higher solar capacity contribution because it recognizes that summer peaks are more frequent and longer duration than the winter peak.
But you understand that in the docket where the commission set the value at 11.8 cents, again, that was a fully litigated proceeding that concluded 8 months ago and included a review by an statutory independent third-party consultant, correct?
I understand that the value that I'm recommending here is different than what was adopted then.
Finally, on the contribution of solar output to avoided distribution and transmission capacity costs, on page 11, line 13 of your testimony, I believe you state that you utilized NERA regressions based on desk historical peak growth and transmission and distribution investments over the period from 2009 to 2025 using desk FERC Form 1 data for the historical portion of this period through 2019, as well as a 6-year forecast of T&D investments and load growth. Is that your testimony?
Yes.
Are the utilities transmission and distribution investments as reflected in FERC Form 1 exclusively load growth?
No, they're not, and that's the reason you do the regression, is to pick out what portion of the utilities investments are related to load growth. So the whole purpose of the NERA methodology is to determine what part of the utilities investments are related to load growth, but they certainly are not all related to load growth. That's why you do the analysis.
And so your testimony is that your analysis does not overstate the benefit by including costs for grid hardening and life cycle. Is that correct?
Not at all. I did the analysis in order to separate those kind of costs out from the investments that are related to load growth.
Okay. Finally, are you aware that the Commission in Docket 2019-184E approved a total NEM methodology value of solar of 3.52 cents per? Oh, I'm sorry. Let me do it in megawatts. $35.2 per megawatt hour.
I mean, I'll accept, subject to check that was the number.
And your value in this docket is converted to megawatt hours would be approximately $143 per megawatt hour. Is that correct?
Yes.
And out of transparency, do you think that perhaps you should have let the Commission know that you refused to accept their numbers that were arrived at after a fully litigated proceeding? Do you think that would have been in the interest of transparency, that perhaps you should have done that in this docket?
Well, I was trying to present, my view of what the 25-year levelized benefits of distributed solar are in South Carolina using the best available information that I had. And I realized that some of these numbers are reviewed regularly, but I thought that the Commission would benefit from what I think is a current and realistic long-term perspective on these values.
Thank you, Mr. Beach. I have no further questions.
Thank you, Mr. Gissendanner. Duke Energy Carolinas, any cross? And Duke Energy Progress, any cross?
Madam Chair, this is Ashley Cooper on behalf of Duke Energy. We have no questions for this witness.
Thank you, Mr. Cooper. Office of Regulatory Staff?
Jenny Pittman for ORS. We have no questions for this witness.
Thank you. Have I missed anyone on cross? I jumped around there. I apologize. I'll try to do better next time. Commissioners, any questions for this witness?
Madam Vice Chair.
Commissioner Powers.
Thank you. I appreciate that you used the word realistic, and of course, a lot of us new, and we're trying to grasp all this. In your testimony, you talked about with specific benefits and costs that we shouldn't assign a zero value to certain categories or to categories that may come up. but that there would be a range of reasonable values. I think with the commission, how do we determine a value for these zero value components if we're not provided with one? And also, is this something that we should have our own expert provide for us?
Well, Commissioner, I hope my testimony helps you fill in some of those zero values. With respect to Dominion, my testimony does provide values for things like avoided transmission and distribution and the fuel hedging benefit that are zeros in Dominion's analysis. I mean, these benefits have been looked at in other studies and in other states, and so there are methodologies out there for valuing these benefits, and I would encourage you to look at them, especially things like avoided transmission and distribution is valued by most other states that look at these issues. Value avoided T&D.
Well, I guess that leads me to my next question is where specifically would you suggest we look?
Well, my testimony discusses, a methodology that's widely used by other utilities in calculating marginal or avoided transmission and distribution costs. That's the NERA methodology. There are marginal cost studies that have been done by a whole range of utilities in the U.S. I think that in North Carolina, I know there are avoided T&D values that are used for energy efficiency programs there. So there definitely is a lot of information, certainly on that particular component that's available.
Thank you, sir.
Thank you, Commissioner Powers. Any other commissioners?
Vice Chair.
Commissioner Caston.
Throughout the course of this proceeding, thank you for participating and answering questions and providing your testimony, Mr. Beach. Throughout this proceeding, I've heard 20 years and 25 years of life of something. I'm assuming that something, is that a solar panel? What exactly are we talking about that has a 20 or 25 year life?
Sure, it's the whole system. Solar panels today typically carry a 25-year warranty, and they are, warranted to produce, 85% of their original output after 25 years, something like that. So the panels, have a warranty for 25 years. Increasingly, the inverters that transform the DC electricity produced by the panels into AC are also carrying warranties as long as 25 years. In the past, those warranties have been a little shorter, so there has been an expectation that you might need to replace the inverter before the panels reach the end of their life, but increasingly inverters have 25-year warranties too. So what we're talking about here is a complete system that you can expect to operate and produce power for 25 years. I believe yesterday there was some testimony about degradation rates, and the output does degrade over time, and by about 0.5% per year is kind of the industry standard. So over 20 years, after 20 years at 0.5% a year, the system will produce 90% of the power that it produced in the first year.
Is that 25 year warranty, is that ubiquitous through the industry, or is that just some of them? Some of them still 20 years, 10 years, 15, or is 25 pretty much tee to green, what everyone uses?
I believe 25 years is the standard for panels. Like I said, I think the inverters, there's some that have warranties that long. Others may be 15 or 20 years for the inverters.
Are there any existing systems that have, I guess, been in place 20, 25 years? How is that verified?
Sure.
I mean, is there empirical information? I'm sorry, answer.
Yeah, I think that there's a growing amount of empirical data on the life of these systems. And I mean, I can add one data point. I've had solar on my house for 18 years. The system is working. I have not replaced anything. I've not had an outage in 18 years. I've measured the degradation of my system output at 0.4% per year, so a little bit less than the industry standard of 0.5% a year. I offer that as one data point. But there's, obviously 20 years ago there weren't a lot of solar systems, but there were some. And I think that as time goes on, we're going to get better and better data on exactly how long these systems last and what their performance over time is.
Thank you, Mr. Beach.
Any further commissioner questions? Any react?
Thank you, Madam Vice Chair. Just a couple of questions, if it please the Commission.
Please proceed, Mr.
Mr. Beach. Thank you, Madam Vice Chair. Mr. Beach, just one thing about your conversation with Council for Dominion Energy South Carolina, Mr. Gissendanner. Repeatedly referred to customers being paid. Now, would you characterize net metering in that way?
Yeah, I think that it's important. I don't think that that's the completely accurate characterization. First of all, the avoided costs, for example, that he focused on, we're using those to evaluate net metering as a program. We're not using those to actually pay solar customers. We're using those avoided costs to make sure that there isn't a cost shift. It's not like a power purchase agreement where the solar customers are actually getting paid that avoided cost value. Customers are getting credits for the power that they export to the grid, but those credits are not, at this time, they're not set based on avoided costs. They're referenced to the retail rate.
All right, thank you, Mr. Beach. Madam Vice Chair, I don't have anything further.
Thank you, Mr. Kelly. Since those pertain to Dominion, any recross, Mr. Gissendanner, on those limited questions?
No recross.
Thank you. Thank you, Mr. Beach. We appreciate your testimony and your appearance. You may step down.
All right, thank you very much.
Mr. Cully, will you be presenting the next witness?
No, I will not. I believe counsel for possibly for NCSEA will be presenting.
I'm sorry. Who is that going to be?
Madam Vice Chair, this is Peter Ledford with the North Carolina Sustainable Energy Association. I'll be presenting the next witness on behalf of NCSEA and the Solar Energy Industries Association.
Thank you, Mr. Ledford. Please proceed.
Thank you, Madam Vice Chair. We would ask that we call Mr. Justin Barnes to the stand.
Okay.
Hello, everybody.
Good morning, Mr. Barnes. Close to afternoon here, but would you state your name for the record, please?
My name is Justin R. Barnes.
Thank you. The court reporter will swear you in.
Mr. Barnes, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much.
Go ahead,
Thank
Mr. Ledford. Sorry.
My apologies. Mr. Barnes, please state your name and business address for the record.
My name is Justin R. Barnes, and my business address is 1155 Kildare Farm Road, Cary, North Carolina, 27511.
And on whose behalf are you testifying?
I'm offering testimony on behalf of the Solar Energy Industries Association and the North Carolina Sustainable Energy Association.
And did you cause to be pre-filed in this docket on October 8th, 2020, direct testimony consisting of 35 pages and one exhibit numbered JRB-1?
I did.
And was that testimony prepared by you or under your supervision?
It was.
Do you have any changes or corrections to your pre-filed direct testimony at this time?
No, I don't.
And if I were to ask you the same questions today, would your answers be the same as given in your direct testimony?
They would be the same.
Madam Vice Chair, at this time, I move that the direct testimony of Mr. Barnes be copied into the record as if given orally from the stand.
The free-for-all direct testimony of Mr. Barnes will be admitted into the record.
Thank you, Madam Vice Chair. And I would also move that the one exhibit attached to Mr. Barnes' pre-filed direct testimony be entered into the record and identified as the next composite hearing.
Mr. Barnes' pre-filed exhibit JRB-1 will be marked for identification as hearing exhibit number 9 and admitted into the evidence of this case.
Thank you. And Mr. Barnes, did you cause to be pre-filed in this docket on October 29, 2020, rebuttal testimony consisting of 17 pages?
I did.
And was that testimony prepared by you or under your supervision?
It was.
And do you have any changes or corrections to your pre-filed rebuttal testimony at this time?
I have no changes.
And if I were to ask you the same questions today, would your answers be the same as given in your testimony?
They would.
Madam Vice Chair, at this time, I move that the rebuttal testimony of Mr. Barnes be copied into the record as if given orally from the stands.
The pre-filed rebuttal testimony of Mr. Barnes will be read into the record as if given orally from the stand.
Thank you. Mr. Barnes, did you prepare a summary of your testimony?
Yes, I did.
And can you read it at this time, please?
Yes. Commissioners, thank you for the opportunity to testify before today. My name is Justin Barnes, and I'm the Director of Research at EQ Research, LLC. I'm appearing here on behalf of the Solar Energy Industries Association and the North Carolina Sustainable Energy Association. The purpose of my direct testimony is to address three subtopics associated with the Commission's review of the costs and benefits of net metering and distributed generation. First, I discuss the general conceptual framework for net metering and DG cost-benefit analyses and offer recommendations on how the Commission should view and analyze the results of such studies. Next, I specifically discussed how direct and indirect economic impacts can be viewed and present examples of how regulatory decisions in 2 other jurisdictions have produced significant disruptions of the rooftop solar industry and accompanying negative economic impacts. Finally, I discuss how DG can support greater resiliency and recommend that the Commission's evaluation of net metering and DG costs and benefits include consideration of enhanced resiliency benefits that result from greater DG deployment. On the issue of the general nature of analysis of benefits and costs, I recommend that the Commission take a broad and forward-looking view when determining the scope of potential benefits to be included in the evaluation. With respect to breadth, the scope of the benefits should include all benefits reasonably expected to arise from DG growth, even if those benefits are difficult to quantify or have associated uncertainty. These qualitative or non-quantitative benefits should still be given weight in the assessment of the costs and benefits of net metering. With respect to adopting a forward-looking outlook, the Commission should consider ways in which new technologies such as on-site energy storage and smart inverters could modify the results of the analysis. Such an outlook is reasonable because the Commission is engaged in an exercise of evaluating future DG rates and rate structures with proper signals and mechanisms, and these new technologies can dramatically enhance DG value. On the issue of direct and indirect economic impacts, I recommend that the Commission give substantial weight to potential negative economic impacts of utilizing a narrow scope of benefits to determine DG value and utilizing that value in setting DG rates. Such substantial weight is supported by the express directive in Act 62 that the evaluation of costs and benefits include direct and indirect economic impacts and statements of legislative intent that speak to avoiding disruption of the growing DG market and building on the success of Act 236 of 2014. Finally, with respect to the value of DG in enhancing grid resiliency, I recommend that the Commission, at a minimum, incorporate enhanced grid resiliency as a qualitative benefit if it determines that it cannot be reliably quantified. The Commission should adopt a forward-looking approach to evaluating this future benefit stream and acknowledge that net metering itself has and will continue to support greater resiliency by supporting the installation of the existing DG systems that can later be retrofitted with battery storage. In this respect, I urge the Commission to view the benefits of net metering and DG as they could be under policies that create more refined incentives for customers, not just policies as they have been in the past. Thank you again for this opportunity. And with that, I will move on to the summary of my rebuttal testimony. In my rebuttal testimony, I respond to the direct testimony of Dominion Energy South Carolina witness Everett and Furtick on topics related to the inclusion of direct and indirect economic impacts in the evaluation of the costs and benefits of net metering and so-called net metering best practices. In Section 2 of my rebuttal testimony, I illustrate that Dominion witness Everett's recommendation that the Commission's evaluation of net metering costs and benefits not factor in direct and indirect economic impacts is contrary to an express directive from the legislature in Act 62, and that witness Everett's stated concerns about the reliability of economic impact estimates are unfounded. With respect to witness Everett's criticisms that economic impacts can only be inferred rather than directly measured, I explain that all modeling relies on the inference of unmeasurable values from known values. In response to witness Everett's criticisms that it's not possible to isolate specific economic impact net metering from broader solar industry economic impacts or define a so-called base case from which to measure incremental impacts, I provided analysis that isolates the incremental impacts of net metering and demonstrates that net metering is responsible for the vast majority of economic impacts presented by Dr. Frank Hefner on behalf of the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, and Vote Solar. In Section 3 of my rebuttal testimony, I reviewed Dominion witness Everett's presentation of national trends in net metering policies governing customer-sited distributed generation. In my review, I first point out several factual inaccuracies in the information presented by witness Everett. I then illustrate how witness Everett's conclusions on so-called trends at turns conflicts with some of the very information she presents, or reached only through a misleading presentation of certain statistics on legislative and regulatory actions, and lack of attention to details that are critical to understanding exactly what those determinations mean and their associated origins and outcomes. I conclude by urging the Commission to withhold making any judgment on the national picture of net metering policy and refinements until it can be presented with a more complete and accurate assessment in the context of specific utility tariff proposals. This concludes my summary of my rebuttal testimony.
Thank you, Mr. Barnes. Madam Vice Chair, Mr. Barnes is available for cross-examination.
Thank you, Mr. Lakeford. Cross-exam, South Carolina Appleseed Legal Justice Center.
We have no questions for this witness. Thank you.
Thank you. Nucor Steel, South Carolina.
No questions, Madam Chair. Thank you.
Alder Energy Systems.
Questions, Madam Vice Chairman. Thank you.
Dominion Energy, South Carolina.
No questions, Madam Chairman. Thank you.
Thank you. Duke Energy Companies.
No questions, Madam Chair. Thank you.
Thank you. Office of Regulatory Staff.
Jenny Pittman for ORS. We have no questions for this witness.
Thank you. Commissioners, any questions?
Madam Chair, this is
Who did I leave out?
this is Kate Lee representing. This is Kate Lee representing State CCL in Upstate Forever. I do have just a couple of questions for Mr. Barnes, if that's okay.
I thought these were joint witnesses.
Mr. Barnes, I believe, is a witness for NCSEA and SIA, but not for, say, CCL and Upstate Forever.
I apologize. Mistake. Please proceed.
Okay, thank you. Just a couple of questions, Mr. Barnes. Were you listening to the testimony from Dr. Wright earlier?
I listened to most of it. I caught probably most of it, but I missed a few pieces here and there, but for the most part.
Did you hear the portion of his testimony where he referenced a Nevada order?
I did hear that part.
Thank you. And are you familiar with that order that he referenced?
I believe I am. There were several orders that kind of came out at about the same time in Nevada, in kind of succession. I believe I'm familiar with that particular order, but it's quite long, so there might be a few details I'm not aware of.
Very well. And do you have any understanding of the results of that order?
Well, in terms of the results, with respect to changes in customer DG rates, essentially what the Public Utilities Commission of Nevada adopted initially was a very kind of dramatic increase in fixed charges, approximately like 3 times over what they were current at the time, and a fairly dramatic reduction in the compensation rate for excess generation, that is excess electricity exported to the grid by net metering customers. With respect to what effect that had on the solar industry, as I discussed in my direct testimony, based on statistics compiled by the Solar Foundation, the impact looks to be, over the next couple of years, the loss of about 4,000 jobs.
Thank you. No further questions.
Thank you, Ms. Lee. Commissioners, were there any questions? Commissioner Powers.
Mr. Barnes, in your rebuttal testimony, you talked about that with the witness Everett's review of 20 states is not comprehensive. And of course, I think there's some question here as to what really are comparable or what states should be considered. What would be your analysis about this as far as what states should be looked at, or should additional states be looked at, or exactly what was your conclusion or solution to that issue you raised?
Well, I think part of my objection was that if you call something comprehensive, and you're talking about, a national picture of policy, then I assume it covers 50 states, right? Assuming that even in states where, say, an action to revise or reform net metering hasn't been taken, those are still within that evaluation framework, because they've obviously decided that, at least for the time being, then, what we have as far as a net metering policy or a DG policy right now is good enough. We're happy with it. As far as specific states that might be most comparable to South Carolina, it's kind of different to just kind of pick one or two, because I think, what's really valuable about that, a comprehensive picture, is that if you look at every state, you see this kind of entire spectrum of different approaches that have been used. And that, seeing kind of the diversity of those approaches, I think, is valuable in devising policy refinements and policy reforms, in terms of just, being able to learn from other jurisdictions. If kind of pressed to point out a few states that I think have done, a pretty good job of pursuing refinements to net metering, I think, California and New York come to mind, and I would actually clarify that in New York has not gone to a value of DER's framework. I believe that was a reference that Witness Everett made. It hasn't gone in that direction for residential systems or customers with loads of up to 750 kilowatts. So VDER in New York is essentially reserved for community solar and off-site remote net metering projects and very large customers. But I think California, Nevada, New York are, if not comparable, I think good approaches to developing refinements to customer generation policies.
Thank you, sir.
Any other commissioners?
Vice Chair Belser.
Mr. Caston, you're hidden behind the podium.
Thank you, Mr. Barnes. In your opening testimony, and I made the mistake of trying to write and listen at the same time, and I always do that poorly. But you said something about, I think, cautioning the PSC to consider negative something. Was it negative benefit cost of what? I mean, I missed that. Could you kind of clarify that for me?
Sure. The negative economic impacts that have been associated with a couple of regulatory decisions, one in Arizona and one in Nevada. This is the Nevada case that that one of the other attorneys asked me about, that were essentially kind of caused by a dramatic change in customer generation policy. So in both cases, there were some fairly significant drop-offs in installation, and then accompanying job impacts, where certain providers either left the state or were forced to dramatically reduce operations. So that's what negative economic impacts is, basically lost jobs, and then what we refer to as induced impact on that.
Okay, thank you. Did I see? I think in the second part of your opening testimony, are you saying that Act 62 intends for the PSC to continue enabling the solar market? Did I understand that correctly?
I think I suppose that's one way to put, avoiding disruption and building on the success. I mean, using different words, but I guess when I look at Act 62, I see, 4 aspects of conducting a cost-benefit analysis that, at least in the bill, in the law, are expressly called out. One of those is, we have references to cost of service. We have references to marginal costs. We have references to direct and indirect economic impacts. And I believe there was another point, and I'm forgetting exactly what it was, but nevertheless, the way I look at that is kind of the way I look at rate making in general, where you've got a series of considerations that, sometimes maybe have competing, right? And it's difficult to accomplish everything at the same time. And where I see, I think what you just mentioned is, if you were thinking about reducing an identified subsidy to the extent practical to me in the context of Act 62 means to the extent practical, while also avoiding disrupting the solar industry. Does that answer your question?
Well, yes, that is what I thought I heard, and because of that, I actually went to the specific legislation just to find out what it says too, because I don't remember all that either. But if I'm reading this correctly, 58-40-20A, it is the intent of the General Assembly to, 1, build upon the successful deployment of solar generating capacity through Act 236 of 214 to continue enabling market-driven private investment in distributed energy resources across the state by reducing regulatory and administrative burden to customer installation and utilization of online distributed energy resources. What is market-driven?
Well, unfortunately, it's not defined. I guess one way to look at market-driven would be private investment in customer-sided generation. So, the way I think about that kind of private investment is a little bit different than I think about, say, utilities making investment in grid-scale farms. Market-driven is the private investment that customers make on their own outside of kind of the monopoly utility complex. And then you have a different variety of investment that might be associated with like broader utility resource planning. It's certainly something that's not driven by the market in the same way that driven by the competitive market in the same way that a lot of other goods and services are kind of considered to be market driven.
Okay, so you're not implying that Act 62 and what I just read is suggesting that the PSC drive the market or help drive that market?
Well, with respect to, if you're referring to the PSC, I suppose, driving the market by, adopting what might be considered excessive compensation to customers. I think it really needs to be viewed, or that potential outcome or scenario is something that does need to be viewed in the context of the other statements of intent. I don't think Act 62 is telling you to go and look at the economic impact and say, okay, well, customer generators deserve 40 cents a kilowatt hour because that's what the study results in. I think it's telling you to, again, kind of enable private investment in customer-sided generation, building upon the success of past policies, while also balancing that with accomplishing the other goals, like looking at long-term marginal costs, looking at the potential for subsidization. I really see kind of the statement of intent as something of a a reference to, thinking about like gradualism in rate making, which is something that's really difficult to define, but you often kind of know it when you see it. And to me, that's where kind of you can maybe tolerate a certain amount of potential subsidy if you just determine that one exists, because you're also looking out for all of these other factors and things that need to be retained in order to successfully implement Act 62. I apologize if I'm not fully answering your questions. I'm doing my best.
No, I understand. I'm just kind of looking further down the law here. Okay, thank you very much.
Any further questions, Commissioner? Any redirect?
Yes, Madam Vice Chair. I just have a couple of clarifying questions. Mr. Barnes, Ms. Lee asked you about the consequences in Nevada from their 2016 net energy metering order, and then you subsequently had a conversation with, I believe it was Commissioner Powers. It was kind of hard for me to see. And you mentioned that Nevada was a good example of a state that had gotten policies right. Subsequent to the 2016 Nevada decision on net metering that Ms. Lee was discussing with you, did Nevada revisit its net energy metering policies?
Yeah, I did, and I certainly should have clarified that. So after, we'll call it the disruption caused by the Public Utilities Commission of Nevada, their decision, shortly thereafter in the next legislative session, they essentially went back and voided that decision and ended up substituting an alternative that more or less returned net metering back to what it had been prior to the PUC decision, with a few kind of modifications that occur over time as additional capacity is installed. So there's kind of a bit of a step-down system that's in place right now, but essentially they restored net metering after a lot of dissatisfaction associated with the Commission's decision.
Thank you, Mr. Barnes. Madam Mayor, that was all I had.
Thank you, Mr. Ledford. Any recross on that limited question?
Madam Chair, it's Matt Gissener from Dominion. I don't have any recross of this witness, obviously, but I did want to take the opportunity, since Commissioner Powers had referenced witness Everett's detailed look at 20 states. I believe yesterday during questioning by the commission, Commissioner Williams from the 1st District had pointed out to Mrs. Everett that her page 3 of her exhibit listed 20 states, but that North Carolina appeared to have been double counted. It was listed twice in the list of 20 states, and Mrs. Everett indicated Commissioner Williams that she would have me respond and get back to Commissioner Williams. So I am letting the commission know that Mrs. Everett has confirmed that North Carolina was double counted, and when she stated 20 states in her summary yesterday, that was a misstatement, and that she misspoke, and that it should have been 19. So I just wanted to make the commission aware of that.
Thank you, Mr. Gissendanner. Appreciate you relaying that information. If there's nothing else for Mr. Barnes, thank you for your testimony and for your appearance, and you may step down.
Thank you, Vice Chair, Commissioners. Have a good afternoon.
You too. Thank you. Okay, are we back to Duke? Is that where we are?
Madam Chair, this is actually Cooper on behalf of Duke. Yes, we are, and we're prepared to call our next witness if Madam Chair would like us to proceed at this time.
I would like, and parties, just to reiterate what I stated earlier, because we have a commission meeting at 2 o'clock, We would like to go as close to 1 o'clock as we can, so that, because when we break for lunch, it'll be a longer than usual break and won't come back until 2:45. So if we could proceed, I know we can get the director up and maybe some of the cross. Thank you.
Thank you, Madam Chair. At this time, the companies would call Bradley Harris.
Hello, can you hear me?
Yes, we can. Please state your name for us.
My name is Bradley Harris.
Thank you, Mr. Harris. The court reporter will swear you in.
Mr. Harris, if you would raise your right hand. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Please proceed, Mr. Cooper.
Thank you, Madam Chair. Mr. Harris, by whom are you employed and what capacity?
I'm employed by the Duke Energy Corporation as a rates and regulatory manager, where I'm responsible for strategic rate design projects in Carolinas and Florida.
Mr. Cooper, we're again having trouble hearing you. Can you test for me? Mr. Cooper.
Madam Chair, I'm sorry. I didn't know that was to me. Yes, can you hear me better now? Test 1, 2, 3, 4.
That's coming up a little bit. Keep going, please.
Okay, test 1, 2, 3, 4.
That's good. Thank you very much. Sorry to interrupt.
Thank you. Thank you. Sorry for the issues. And Mr. Harris, did you prepare or cause to be prepared 14 pages of direct testimony that were pre-filed with the commission in this proceeding?
Yes.
If I asked you the same questions that were asked in your pre-filed direct testimony this morning, would your answers be the same?
Yes.
Madam Chair, I would ask that Mr. Harris's pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Harris's pre-filed direct testimony will be entered into the record as if read from the stand.
Mr. Harris, did you also prepare or cause to be prepared 11 pages of rebuttal testimony that were pre-filed with the commission in this proceeding?
Yes.
And if I asked you the same questions that were asked in your pre-filed rebuttal testimony this morning, would your answers be the same?
Yes.
Madam Chair, I would ask that Mr. Harris's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Harris's pre-filed rebuttal testimony will be entered into the record as if given orally from the witness stand.
Mr. Harris, did you also prepare or cause to be prepared 2 exhibits that were attached to your pre-filed rebuttal testimony?
Yes.
Do you have any changes to those exhibits at this time?
No.
Madam Chair, I would ask that Mr. Harris's pre-filed rebuttal exhibits be entered as the next composite hearing exhibit.
Mr. Harris's rebuttal exhibit 1 and rebuttal exhibit 2 will be entered as a composite exhibit. They will be marked for identification as hearing exhibit 10 and admitted into the evidence of this case. Thank you.
And Madam Chair, at this time, I would like to go through Mr. Harris's summary in a Q&A format.
Please proceed.
Okay. Mr. Harris, what is the purpose of your direct testimony?
The purpose of my direct testimony is to analyze certain cost of service implications under existing net energy metering programs as prescribed by Act 62. Specifically, I analyze whether net energy metering customers had an adequate rate of return as a separate customer class and the impacts on long-run marginal costs under those programs.
Mr. Harris, how did the companies evaluate cost of service implications of existing net energy metering programs?
To evaluate the cost of service implications of net energy metering programs, the companies performed embedded cost of service studies. The purpose of these studies were to estimate the electricity bill impacts on residential customers arising from net energy metering customers, to estimate both the unwarranted and gross cost shifts to other residential customers from net energy metering customers, and to determine whether net energy metering customers provide an adequate rate of return. These are particularly relevant in the net energy metering context, given that the usage profile of net energy metering customers is such that costs may be shifted to non-net energy metering customers because the rates may not actually reflect the cost to serve net energy metering customers. To determine the cost shift in existing net energy metering customers, the studies relied on the cost of service studies developed for the 2018 rate cases because those studies are utilized to develop current base rates. Two filters were applied to the company's data on net metering customers. One, to exclude customers with less than 9 months of data, and two, to exclude customers that generated less than 50% of their gross load. This was done to ensure that the data was representative of net energy metering customers. The studies showed that adding solar reduced imported kilowatt hours by 20 to 40%, but only reduced the maximum demand by less than 10%, highlighting the fundamental decoupling of energy usage from demand that often arises under net energy metering programs. Based upon these metrics, the studies ultimately concluded that a cross-subsidy exists under the current net metering policies in the range of $30 to $64 per month. Finally, the studies found that separating net energy metering customers into a separate customer class would result in an inadequate rate of return to the utility because if net metering customers were in a separate customer class, these costs could not be shifted to non-net metering customers.
How do companies quantify customer generators' impact on the company's marginal cost as required by Act 62?
My analysis values excess energy exported to the grid as functionally similar to energy exported under scheduled purchase power in both Duke Energy Progress and Duke Energy Carolinas, which is the same value as exports from a qualifying facility under PURPA. If a customer consumes energy from behind the meter generator, behind the meter generator, the valuation should be similar to if a customer reduced their consumption via an energy efficiency or demand-side management program.
Mr. Harris, please state the purpose of your rebuttal testimony.
In my rebuttal testimony, I respond to certain items raised by ORS witness Ori regarding net energy metering methodology and items included in the embedded cost of service studies, marginal cost of service studies, as well as to the recommendation of witness Beach, who testified on behalf of various interveners in this docket, that a narrow cost-benefit methodology should be used by the Commission in evaluating net energy metering programs.
Do you agree with certain of the direct testimony submitted in this docket regarding cost of service analysis?
Yes. I agree with ORS witness Ori that the Commission should consider both embedded and marginal cost of service perspectives. And I noted the similarities between my calculation of the cross-subsidy occurring under the current net metering programs between $30 to $64 per month and ORS witness Ori's calculation of roughly $45 per month. I did not, however, agree with ORS witness Ori that the embedded cost study could use either historical or future conditions because existing metrics approved by the Commission in a base rate case must be approved. Therefore, any changes in allocation methodology would require a base rate case and Commission approval. In response to ORS witness Ori's concern regarding the company's use of a summer coincident peak allocation method, I note that this method was approved by the Commission as just and reasonable in the most recent rate cases in both Duke utilities, and it would be inappropriate to use a new methodology that wasn't established in a base rate case. I would also note that ORS witness Ori's reference to Glenn Snyder's testimony on behalf of the companies in the avoided cost docket is not relevant to the embedded cost study because the avoided cost docket did not involve an embedded cost study. Finally, I agree with witness Beach's statement that the best practices for designing cost-benefit analysis for distributed energy resources should emphasize consistency with similar analyses that are standard practice for all demand-side resources because a cost-effective framework is already in place for energy efficiency and demand response resources that can contribute towards evaluating the system benefits for distributed energy resources. As such, although there may be variations in the tests and inputs utilized by the parties, I believe that the parties are aligned on the key points within this generic docket.
Does that conclude your summary?
Yes, it does.
Okay. Thank you, Mr. Harris. Please answer any questions of council or the commission.
Thank you, Mr. Cooper. Dominion Energy, any cross?
No cross for this witness.
South Carolina Appleseed Legal Justice Center.
We have no questions for this witness, Madam Vice Chair. Thank you.
Nucor Steel, South Carolina.
No questions, Madam Vice Chair. Thank you.
Vote Solar.
No questions, Madam Vice Chair. Thank you.
North Carolina Sustainable Energy Association.
No questions, Madam Vice Chair.
Solar Energy Industries Association.
No questions, Madam Vice Chair.
Upstate Forever, CCL, SACE.
No questions. Thank you.
Alder Energy Systems.
Thank you, Madam Vice Chair. Alder Energy does have questions.
Please proceed.
Thank you, Madam Vice Chair. Good afternoon, Mr. Harris. My name is Taylor Spear. I'm going to be asking you some questions about your testimony today. Do you have your testimony in front of you?
I do.
Please turn to page 5.
Direct or rebuttal?
Direct. Thank you for clarifying.
Give me a second. I'm there.
Okay, line 23, please, sir. Do you agree that your direct testimony in this proceeding, that it should be noted that the goal of Act 236 to establish and promote net energy metering?
That's correct.
You agree that Act 62 requires that for both residential and non-residential customers, don't you?
Act 62 has several requirements that have been discussed extensively to reduce any potential cost shift, in addition to create market-driven adoption of solar in the future for both residential and non-residential.
Right. Whatever criteria has been established by Act 62 applies equally to residential and non-residential customers investing in customer-generated solar, correct?
Correct.
And Act 62 requires that the Commission consider cost of service implications of customer generators in both residential and non-residential classes, correct?
Correct.
And Duke has failed to do that, correct?
The Act 62 requires to reduce the cross-subsidization as much as practical. 95% of net metering customers, roughly 95% of net metering customers in Duke territories in South Carolina are residential, and it's residential where we have the largest concern about excess compensation leading to the cost outweighing the benefits of the program, and those costs being picked up by non-net metering customers on the residential side. So because the vast majority of the issue is on the residential side, and it takes a lot of work and analysis to do that, we thought that we would focus on that side rather than the non-residential side. I think as you've mentioned previously, non-residential rate design is more complicated. Non-residential load shapes are more different than residential load shapes that tend to follow a similar pattern. We also had less concerns that the rate design, especially for non-residential customers with demands of greater than 30 kW, that the compensation was in excess of the benefit, and therefore there was a cross-subsidy.
You mentioned a number of times what we are concerned with. Who is we when you just testified?
We being Duke Energy companies.
Yet what's important here is what concerns the commission, correct? And Act 62 mandates that the commission be concerned with non-residential customer-generated solar. Is that right?
That's correct. And what I'm trying to establish is the company's belief that we have met the goals of Act 62 in analyzing potential cross-subsidy and so that in a future docket we could look at reducing that to meet Act 62's requirements.
You testified that the purpose of the embedded cost to serve study was to look at bill impacts on resident customers of NEM programs exclusively. Isn't that right?
I only conducted a embedded cost of service study for residential customers.
So you would agree with me then that your conclusions that are represented in your written testimony, the conclusions that you've represented in your testimony today orally, only apply to residential customers?
That's correct.
So your cost to serve study did nothing to tell the commission about what is the cost of service to non-residential customers.
We have the goal and spirit of Act 62 is to reduce the cost shift as much as practicable, and that's related to these studies. Since 95% of our net metering customers are residential, that's where we focused our analysis. If you are concerned and would like, if the commission would like to explore non-net metering, non-residential net metering customers, and if the compensation is excessive there and should be reduced to avoid potential cross-subsidization for non-net metering customers on the non-residential side, I don't stand in opposition to that.
I think that you answered the question. I just want to make sure that we understand clearly that the cost of study analysis, the cost to serve analysis that you prepared does nothing to address any sort of cross-subsidization that would be within the non-residential rate class.
That's correct.
Let's move, please, to the assumptions in your data set, even for residential. Your data set was for 2017 information, correct? It did not include information from 2018, 2019, and 2020.
For my embedded cost of service study, it was only 2017. That is correct.
Do you know how many years that would include in your data set, given that the commission's order approving the NEM policies in the state of South Carolina was not entered until 2015?
So we're analyzing the load shapes. We're analyzing current rates based off the 2017 cost of service study, which had a calendar year of 2017. You have to align the cost rates coming out of the cost of service study with the load shapes. Otherwise, you're comparing rates that don't match the load shapes. So we were limited to 2017 for that reason.
Did you hear Mr. Beach's testimony regarding the traditional load profiles of a non-residential customer?
Yes, I was listening. I'm sorry, I cannot hear Mr. Spear.
Mr. Spear, have you dropped again? Okay. I think he's dialing the phone.
Madam Chairman, I apologize. This is now the danger of appearing by cell phone, so I apologize.
We've got you.
Was there a
Do we need to go back to the last question?
Yes, ma'am. Thank you. And
You need the court reporter?
no, ma'am. Thank you. I appreciate you asking. Mr. Harris, the question was, do you remember Mr. Beach's testimony about the traditional load profiles and the diurnal customer generation profile of non-residential customers?
I was listening. I don't know if I have a perfect memory, so if you want to refresh me on any specific points, that would be welcome.
Absolutely. Do you recall testimony that, in his belief, a traditional non-residential customer exports less to the grid because they are not offsetting traditionally as much of their load?
I would answer that by I recall that. Yeah, that was the question.
And you used as an assumption in your study to eliminate all data sets that would include an export value of less than 50% of a customer's load, correct?
I did that for residential. As you have mentioned, I have not done an analysis for non-residential.
Do you have an opinion on what a traditional offset is for a non-residential customer in the state of North Carolina?
I would challenge, because of the diversity of non-residential customers and how they could set up their solar systems, that there might not be one answer to that question. It might be sort of more grouping, and I've not done that analysis.
I think that's a fair point, and I appreciate that. How about specifically your testimony relating it to 50%? Would you agree that traditionally it's less than a 50% offset in the state of South Carolina?
I'm not familiar with the non-residential load shapes in Duke territories in South Carolina.
One of the data sets that you used in your study was that the average customer consumes 1,000 kilowatt hours per month. Is that correct?
Yes, I believe it was roughly 1,000 kilowatt hours.
Surely you would agree that that is not consistent with a traditional non-residential customer's consumption.
I think it depends on the non-residential customer. If it's a small corner store, that would be a non-residential customer, and they might consume 1,000 kilowatt hours. Obviously, if it's an industrial facility or a larger facility, they would consume much more.
Madam Chair,
Cooper.
I've not objected, but at some point, Witness Harris has testified over and over again that he's not completed a C&I study. So we are continuing with question after question about, hypothetically, what would you expect to find in a C&I study? So I just note that for the record, Madam Chair.
Thank you, Mr. Cooper.
Similarly, Mr. Harris, your data input here that the traditional bill reduction for a residential customer participating in customer-generated solar is approximately $1,250 annually.
I'd have to flip to my rebuttal exhibits where those numbers are.
This in your direct. It's page 19, line 18. Page 9, line 18.
No. Yes, that's correct.
We're kind of going back and forth and the range of different kinds of customers that can be in the non-residential rate class, and I certainly agree with you on that point. But you would have to agree with me that...
Just a moment. Is that Mr. Cooper?
There was and I'm sorry, there was a note from Ms. Pittman asking that we please hold up and wait for her, that ORS has been dropped.
Okay, thank you very much. Please, please hold, just a second.
Last thing we heard.
Ms. Pittman, is that you?
Madam Vice Chair, we had some technical difficulties and were dropped from the line just a few minutes ago. So we hadn't heard the and whatever happened after that.
I'm sorry, you broke up there a second. You haven't heard what?
We dropped the line, I think, when Mr. Cooper got on to object, and so we haven't heard anything since the objection and whatever exchange happened between Mr. Harris and Mr. Spear.
Well, Mr. Cooper made a note for the record that it was not an objection, and then I think we were back into a question regarding testimony on page 9 of Mr. Harris's testimony. So, Mr. Spear, could you repeat your last question, please?
Yes, ma'am. Given the understanding that we have both had in our conversation today that there's a large range in a non-residential rate class between customer-generated solar. So you've agreed with me that on page 9, line 18, that you're representing that an average bill reduction for a residential customer in DEC territory is approximately $1,250 annually. Notwithstanding the great level of range in the non-residential rate class, you would agree that an annual savings for a non-residential customer is going to be a lot more than $1,250, don't you think?
Madam Chair, this is Ashley Cooper. I object. I'm sorry, this is Ashley Cooper on behalf of Duke Energies. I object. This calls for speculation by the witness. There's no foundation, and I'm hard-pressed to see the relevance.
I'm going to sustain your objection. Mr. Spear, would you move on, please?
No questions. Thank you. I'm finished.
Thank you, Mr. Spear. Any redirect? I'm sorry, excuse me. ORS.
Jenny Pittman for ORS. We don't have any questions for Mr. Harris.
Thank you, Ms. Pittman. Commissioners.
Vice Chair.
Commissioner Caston.
You'd mentioned 95% of the net energy metering is residential, correct?
That is correct.
And I've seen so many numbers, and I'm not sure if I've seen these numbers, but whatever that total number is, how many of the total net energy metered customers are residential? Like if it's 1,000, I assume it'd be, 950. What is it?
I don't have the numbers in front of me, but I believe it's somewhere, and Mr. Huber might have more current numbers in front of him, but I believe it's a few. We have several thousand residential, and it's within the hundreds or less non-residential. I do know it's roughly 95% of the number of metering customers are residential.
So the commercial industrial would be the same relative, I guess, 5% or a much smaller number. I'll find that. I'm sure it's in the testimony somewhere. I'll look again. Do you know what the demand is, or whatever you guys call average day load, or for what percentage of the residential is that? I guess would be the.
So the average monthly energy use for residential is right around 1,000 kilowatt hours. Now, for net metering customers, they tend to be slightly larger, so it tends to be roughly 1,200 kilowatt hours per month, and similar go through my testimony to get the exact number if you would like. Similar for demand, which is the maximum power going to these customers. For a residential customer, normally they have what's called a non-coincident peak, a maximum demand of typically less than 10 kW. Does that answer your question, sir?
Yes, sir. Thank you very much.
Commissioner Thomas.
Thank you. Mr. Harris, thank you for answering questions here today. You were talking about the allocation methodology and that it's based on the cost of service studies. And you indicated that 2017 was the most current cost of service study. So that's getting to be a little bit old. And you have any idea when maybe another cost of service study?
It'll be when the companies file a new base rate case. I have no idea when that would be.
Okay, thank you.
Any other commissioners? Mr. Cooper, any redirect?
Thank you, Madam Chair. I do, but it's very brief. Mr. Harris, I want to ask you about, you asked several questions about your resident cost-benefit analysis and the applicability or inferences for C&I customers. Okay. Recognizing that the purpose of this generic docket is to examine the current or the existing NEM program, the existing Act 236 NEM program, isn't it true that your residential studies would be informative for smaller C&I customers?
Objection, Madam Chairman. That's leading. I mean, if he wants to go through the study and ask them how it's applicable, that's fine. But what we've learned is Duke did not perform the study.
Your objection is leading the witness. Mr. Cooper, please rephrase the question.
I'm happy to rephrase the question.
Sorry, just a second. That was Mr. Spear making the objection. Thank you. The court reporter just asked who was making the objection. Mr. Cooper, please proceed.
In this generic proceeding, is the purpose of your cost-benefit analysis to examine the current Act 236 NEM program?
Yes.
Would such an analysis, even if limited only to residential studies, be informative for smaller C&I customers?
To a very limited extent.
And therefore, would it be informative regarding any sort of cost shift?
Similarly, to a very limited extent.
Okay. Thank you very much, Mr. Harris. Madam Chair, thank you very much for the opportunity to conduct just a limited amount of redirect. I have nothing further at this time.
Thank you, Mr. Cooper. Based on the limited redirect, is there any recross? Mr. Spear?
Thank you, Madam Chairman. I do not have any recross, and I appreciate you asking me for the opportunity, but I would like to note something for the record, and I'll turn my video on here.
Okay, can I excuse the witness first?
Yes, ma'am. Yes, ma'am.
Thank you for your testimony, Mr. Harris. You're excused. Okay. Mr. Spear, please proceed.
May I proceed, Madam Chairman? Thank you. Mr. Cooper has argued that the underlying conclusions and data set that were used for the cost to serve study are not relevant, and the Commission sustained that objection with respect to one of the questions. But I just want to note for the record here that Alder's position is that it's highly relevant. It's required by Act 62, and we don't agree with the objection or the notion that it's not relevant.
Thank you, Mr. Spear. Anything before we take a lunch break? Okay, as stated, we have the Commission business meeting. Hopefully we will be completed with that by 2:45, so please check back at 2:45 to resume the hearing. Thank you very much. We are in recess.